eyes here.
Kelsey Fitzsimmons just finished the fight of her life, and she came out on top. Now she's back in the courtroom fighting for probably the most important thing in her entire life, which is being able to spend time with her child. We are joined once again by the brilliant Judge Carol Erskine, who we're always so thankful to have here. And this is Kelsey Fitzsimmons. We're going to be talking about the custody battle. Let's dig in. Hello and welcome to Defense Diaries, beautiful humans. We are so happy to have you here. As always, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
And we are also joined by the beautiful and brilliant Judge Carol Erskine, who we just love so very much here. She gives us so much valuable input in terms of what's going on in the system. Especially, we're getting it from a former judge, a retired judge, and it's just invaluable. I adore you, and I adore the fact that you enjoy spending time with us. I feel so lucky.
And love being here.
Well, thank you so much. We're back in it. There was a hearing today. I think the way that we're going to try to work this, Judge, because I think we'd all need to hear from you. It's more than we'd like to hear from you. I think there's a lot of people out there that need to hear from you because I think it's important so that people have maybe a better understanding of what is going on, how the system works, how the pleadings work, what exactly today was, what should have been expected from a hearing day like today, where you're not going to a full hearing and it's just basically a presentment type deal. And, there's some things that are talked about, but this wasn't the full hearing. So I think all of those things are going to be very helpful to people that may be feeling a certain type of way out there about what may have gone down in court today.
Right.
And there's no one better to tell us than you, Judge. No one.
Well, you're both lawyers, and so you've been at these hearings before. Today wasn't the trial. I think, when we spoke a couple of weeks ago about the motion or Justin's motion for temporary custody, we were explaining what even though it was in a temporary custody motion at the time, I said, this looks like what he wants permanently. This looks like his permanent request, for trial. But in essence, what you're hearing today was a temporary motion by a motion judge, by the way, because she's not the judge that's assigned. In Massachusetts, a lot of the family courts have motion sessions, and you have one judge who's hearing motion. I don't know if the judge that's assigned to the case just wasn't available to hear this case, or whether or not it was just the motion judge today. Because for watching it, apparently there were 16 other cases before that of all kinds of things, people arguing over kids and people arguing over all kinds of different things.
Yeah.
And the judge having to hear all of those before she heard Kelsey's case, because of course they knew that there were a lot of people there. She wanted to clear the courtroom. I thought that was the best way to do it, handle the docket. But it was a busy docket, so it was a motion session. So basically what you're hearing is something very temporary. So what is a judge on a motion session? And by this judge isn't the judge assigned. So, and even by her own statement, there were 216 pages of pleadings filed for this motion session. And she had reviewed all of them because one of the lawyers said, well, it's in the 200 pages. And she said 216. I read them all. So what you have to understand is, even if she didn't say what you wanted her to say, it doesn't mean she's not aware of what was in there. So that's one thing I'll start with. It's a motion session. It's temporary orders. And as you both know, lots of times temporary orders maintain the status quo, particularly when there are just major issues that are contested by both parties, which is the case here. Today is really, the temporary custody is about having a judge say, look, despite what you filed, Justin, the goal is reunification. And she said that. She said, she's the mother. The goal is reunification. So people should be pretty happy about that. Just as soon as she mentioned the goal is reunification, she's saying what pretty much all judges will say in cases like that. Unless parental rights are going to be terminated, like through a DCF case or through another kind of hearing, the goal is reunification. And, I think last time when I was on with you, Bob, I said the way they presented this case and their pleadings was they were presenting it like they were seeking a termination of parental rights, like
Yes.
just get her out of that child's life.
Right.
And frankly, I didn't see anything different in the pleadings today. But I think the judge, I think she did a good job of making clear, look, the goal is reunification. And she also said, in terms of Justin asking, well, we want one visit a week and we want her sitting in this cold, sterile environment with someone, just sitting there watching her. And that's what he wants. And he was pushing for that, as you remember, in his pleadings.
Yes.
What did he want? He wanted this one session at this place, which she's going to pay for, which is like $300 a session or an hour. And she was to pay for it. And then they were to turn over all of their notes and everything about Kelsey to him and his lawyer. It's almost like he and his lawyer are like one person in a way, because everything he pleads is like to me and my lawyer. So I just thought it was interesting. But, the judge wasn't buying it. She's like, that's ridiculous. That's, in terms of how little, this is the goal is reunification. And she used the right words. She said, this, baby needs to connect with the mother. This baby needs to bond with the mother. She said all the right things, in terms of what I would say and what I would want to hear. And, in many, many, many cases that I had where DCF or others were trying to stop a reunification, I would just make clear, look, the goal is reunification, time to increase visits. This is nonsense, once a week, and I would used to say to DCF, and then you're going to come in and you're going to want a trial because you're going to say the child's not bonded to the mother when you created and when you essentially severed the bond by allowing the child to see the mother only 1 week. And so that's what happened here. I mean, essentially, he got the orders that he wanted initially, and maybe I'll chat about that later, but he got the orders that he wanted initially. And it was him who severed the bond after she was found not guilty. Right.
Right. And now he's trying to rely on the fact that, I've been the care provider for all like we all know how this happened, Justin. This is not like you've just been the provider. And I'm glad that you had the opportunity to give people this sort of foundation. So when we get to the hearing and we watch it, they maybe are a little bit more relaxed and can view it through the lens that you've sort of just laid out, which I think is super helpful. And then I pulled up, because you tweeted today about a case, and I pulled up that case. This is that Angelone v. Angelone case.
I think it was yesterday, just for the record.
Yesterday? Sorry.
I think. I could be wrong. All the days blend together.
I think I put it out there yesterday saying, here's the case tomorrow. I mean, The reason we put it out there is because they have been arguing mental health issues. And my point in putting it out there was to say, look, the court has spoken about this for 40 years. Okay. I mean, how many times do you need a court to say this? The court has made clear what happens for 40 years. So yeah, Allie, that's so, and there's some great language in there. I mean, I love that case for the great language.
Yeah.
I've known about that case for like years because I worked in the probate court. I was a guardian ad litem on zillions of cases. And
So yeah, I mean, this case, the probate judge, the court said did not err in awarding custody of children to the wife, despite that the wife had been voluntarily hospitalized for short period for emotional problems. And some of the good language here. So they go into what the husband was looking for, that Gino was arguing the judge erred in awarding that custody because his wife, who had been voluntarily hospitalized for short periods of emotional problems and whose therapist testified during the hearing that she had a predisposition to depression. So he was basically arguing that the probate judge must award custody to the superior of the two fit parents, and that he is the superior custodian by virtue
Yeah.
of the wife's latent condition and his greater emotional stability. And the court recognized that the comparative emotional health of the parents is only one of the several factors that can affect the well-being of their children. And they went on to say that is especially the case where, as is there, the findings indicate that all professionals regard the mother as a fit and suitable parent. And hopefully I highlighted the good parts. This was the other part that I highlighted here. In our opinion, on the evidence before the judge, on the evidence before her, the judge could permissibly conclude A, that the mother there is dealing successfully with her emotional problems. B, that of the two parents, she, despite her problems, can offer the child more room for growth. C, that father has had an obsession with keeping control over the life of his wife and children, which causes much of her stress. And D, the welfare of the children will be best served by granting custody to the mother with liberal and specific rights and visitation for the father. I think there was
Right.
probably
Perfect. No, that's perfect. Because what you highlighted is exactly the reason I posted it. Because first of all, the case is more than 40 years old, and the law hasn't changed. There has to be a nexus between mental health issues and the ability to parent safely. I posted particularly in that case. I thought it was interesting in terms of the parallels, because there are issues where, there's allegations that Justin is, of course, trying to control this. And we've talked about how that all went down when he filed the restraining order and got temporary custody. But I mean, of course, there have been thousands of cases, appellate cases and SJC cases since then, but nothing changes, over and over again. I mean, I had literally hundreds and hundreds of cases where you had parents with mental illness. And, what I had to decide in those cases, was there enough of a nexus between the mental health issues and the safety of the child? And if there wasn't, then the child was going to go back. So that's just how it works. I like the last part of that where they didn't go through all the details. They just said, look, there was enough evidence. The other part that you highlighted was that is exactly what happens, which is the judges rely on the evidence that comes in. The psychologist was essentially a GAL, was an evaluator, and that's why the report came in. It wasn't an expert for the mother. It was a person appointed by the court who was a psychologist, a mental health professional. And so that mental health professional made clear, that she not only could she parent and safely parent, but she was the better parent in terms of growth of the children, and that the father had spent most of his time trying to control her, causing her to be, stressed. So it's an interesting case, and people will cite other cases saying, here's a case where there was enough evidence that that they didn't get custody. But the law stands the way it is, which is why I wanted to just sort of send it out there to let people know, this is the way it is. So, but that was a great summary of it, Allie.
And the thing that
Whoa, you're loud, babe, I think.
Oh, hold on. Let me see. I thought I had it on auto.
I don't know. Is it?
No, it keeps jacking up to this. It's like defaulting to no auto. Sorry about that if I blew eardrums out. The thing that I found most compelling about a 40-year-old case, which is interesting because historically, if you look throughout kind of the course of family law litigation in this country, it's had some massive peaks and valleys, but I really appreciated the fact that the judge recognized the coercive control aspect from the husband / father in terms of the relationship with mom, because that's something that a lot of judges just don't want to hear, and it's something that I've always argued, and it's fallen on deaf ears more times than I'd care to admit. And I argue it pretty vehemently. I'm like, because I always tell my clients, you never want to go to a hearing. You never want, and I don't care if it's the greatest judge known to mankind sitting on the bench. The hope is that you're going to be able to work something out, because you don't want to leave what is going to ultimately turn out to be one of the biggest decisions in terms of how your family is going to move forward for the rest of time, but most specifically until the age of 18, maybe through college, depending on what's going on with funding the college tuition and things like that. But that time frame that you have when the kids are tender age all the way up through their teens, and you don't want to have a judge who's heard, maybe a day, maybe a day and a half, maybe 2 days of testimony, understanding that everybody's trying to put everything in the best light in terms of themselves and trying to put everybody else, namely the other party, in the worst light because it benefits them. Mm-hmm. And you don't want the judge trying to wade through that and figure out what the truth is. And you also don't want to have a GAL, which in Illinois, it's like they've just walked from the mountaintop. Whatever they've decided, the GAL, the judges consider it to be gospel, because frankly, the judges consider them to be in the best position to have investigated it. So right. they really put a lot of weight into what the GAL is going to recommended hearing. So, I mean, at the end of the day, we want this thing to end with both Justin and Kelsey playing nice, coming to an agreement on this thing that's fair to both parties, and that most importantly is in the best interest of the child, and that's the thing where you hope you can get past all this kind of stuff that you see in the pleadings. Like you said off camera, Judge, I mean, he's pleading one thing and then he's saying a different thing in court, so you've got this weird juxtaposition of he's talking out of both sides of his mouth. Where are you at? And I understand that in pleadings, you usually throw everything against the wall and see what sticks. And when you get into the courtroom and you're in front of the judge, and the judge is kind of giving you the stink eye, and the judge is like, I'm going to need you guys to go and talk for a bit, to see where you're at really, and see where we're really starting from. So
yeah, you saw it, you're right. You saw it play out quite nicely. I mean, here he is asking, for just the most restrictive kind of contact ever. Won't give an inch, doesn't want, the grandmother around and all of that, and pleads all of that, making this, just this very intense pleading about it. There's something wrong with the family, all this stuff he writes about it. Then he gets in front of the judge and says, and the judge is like, this is like, this visitation is ridiculous, which is what I would have said. And he's like, oh, you're right, Judge. I mean, even though it's not in my pleading, which he didn't say, but then it's like, Justin and I, my client and I, and Justin, we want reunification. There's nothing in those pleadings that indicates they want anything more than to cut her out of that child's life. That's my view of the pleadings. And, when you're a judge and you're sitting there and you just read 216 pages of, this woman shouldn't ever be near a child, and then your lawyer stands up and you stand up and you say, we want reunification. I look at that, very negatively, because it's really all it is pandering,
right.
And it's like, how, I guess the way I looked at that kind of stuff is like, how stupid do you think I am? Like,
right.
Do you think I don't know what's in your pleadings? Do you think I don't know what you want? You came in here, you want her to go into a visitation center, and now you're like, well, when she says, well, is there any reason she can't have a professional supervisor at home? There's a short period of supervised visitation, which any judge is going to do, because this is a judge who walked into this. She doesn't know anything other than what's in these pleadings. So of course she's going to say, okay, well, we need to reestablish this. And so, but why can't it be at home? And then of course, the lawyer did exactly what I would have done. And frankly, did exactly and asked for what I would have granted, which is, there's not a reason in the world the grandmother can't supervise the visitation. Yes. Not a reason. But
I was wondering why the judge wouldn't have just suggested that.
Yeah, because again, you're talking about a judge who just sort of stepped into this case, and it's a temporary custody. But I will say this: one of the good things I found about people who are observing the family, like a lot of times there would be an assignment, like say from DCF to a parenting partner when children were being transitioned home and they were spending a lot of time out of foster care and at home, like over a period of a few days during the transition. And we'd have a parenting partner in there. And then, maybe the state would come in and say, no, we're not ready to reunify. We don't think it should be reunified. Who's the person that I would listen to? The person that was sitting right there watching the parent with the kids. Yep. And so it's not necessarily a bad thing to have a professional in there, because that's the person who's going to say, I watched this many visits instead of Justin and his lawyer sitting there staring at the visit. Who cares what they think? Because they already have a bias.
Right.
But when you already have a professional, and that professional is going to go in there and watch it, that's the person that's going to come and say, I don't see any problems. You should move to, unsupervised time. So as much as it would be great to have the grandmother, what do you think Justin's going to say? Well, of course she's going to say the visits were great. And of course this. And then the other thing is, and you've probably seen this, when you're in a contested battle like this, and there has to be a drop off and pickup, invariably someone may, who is getting custody, who's getting the child back, is going to say, oh, there were problems during the drop off. The child wouldn't get out of the car. The child was screaming. So then you sort of avoid all that when you have a professional supervisor there who's going to watch that transition, so that you can't just go in there and make up stories, because I would hear that a lot. Then you'd have two people saying this kid was fine, but if you had a social worker who was there, for the supervised visit and for the transition, then, you get a reliable, objective source. So I don't necessarily think it's a bad thing, because basically you're going to have, what you're going to have is Kelsey having someone that's going to be on her side. Right. That's going to say these visits all went well. She's talking, the lawyer was good. She knows she had a plan, right? She's like, okay, we're going to do these supervised visits. She's talking about a period of 10 weeks, and then I want 50-50 custody. And that's pretty reasonable. I don't know if the judge is going to order that, because she took it under advisement, and she might not make any orders, that far into the future. But I think, because you're asking a lot, because I've made orders like that, where you're saying, okay, it's going to be this for 2 weeks, and then it's going to be this for another 2 weeks. I don't know if a motion judge is going to do that. But I think it's a reasonable period of time, because it's pretty hard to argue, right, that when the professional says she's fine, let's move ahead. I think what people have to understand is, the 209A was vacated a few weeks ago, other than no abuse to Justin. Everything was vacated, right? And then now today, he doesn't get, at least I don't think so. We don't see the order, but the judge didn't seem to like the idea of having her go to a visitation center, because the judge was saying, well, do you have a professional in mind? And then, of course, they were like, well, we don't want the person that she picked. And right. And then she's saying, I just picked this person because this person's already a guardian ad litem with the court. Yeah. And, I know this person to be fair. So, then, in my case, what I would do in those cases, I would say, okay, well, guess what? I'm going to pick the GAL. I'm going to pick someone that, that I think is going to be fair. Right. But I think this will, and so you have a judge saying, this mother needs to connect. She needs to bond. This needs to be reunification. No, I'm not going to agree to this 1 hour a week of visit. And of course, they're losing badly at this moment. And what do they say? Judge, we're the ones that called and said 2 days ago, right before the hearing, knowing that a judge is going to order this, and knowing that no judge is going to, going to stop. Right. What do? They call 2 days before, and they're like, Kelsey, come in and you can do a visit with Justin and his lawyer, in your lawyer's office. Again, I mean, I'm just talking as a judge that's heard thousands of cases. Do you think that I am really that dumb that I can't see that this is a manipulation, as opposed to what's being said to the judge? And then the judge said, well, why did it take that long? Why did it take that long? Why 2 days? But she did ask a question about that. And the answer was, that, that there was problems with that wizard thing or whatever.
My
And
family wizard. Yeah.
Or, yeah.
right, that they were only, and that they said they were only going to allow like 1 hour under these, very, stringent circumstances that where they had more control. So, but I just thought it was interesting, talk about pandering. Oh, Judge, we are so concerned about reunification and we want the baby to have a relationship with Kelsey that we called her up a day and a half ago. And let's see, was it like maybe 36 hours ago or whatever?
How
We
convenient.
called her up.
What great timing. Right on the eve
I
of
mean,
court.
I I'm listening. I listen to it, just sort of as a former judge. How I ask myself, how would I interpret that? I would interpret that as a master manipulation.
Yeah.
And from what we know in terms of what kind of manipulation there's been in the past that the judge may not know, it's concerning. It's concerning because if you look back to his affidavit and his filing of the restraining order, he went in there and said, I'm in a situation of coercive control. What you think like some guy out there just knows that language? Coercive control only came into the statute in late 2024 in Massachusetts, October 2024. So, people aren't walking around saying, I know about coercive control, and it's like this real common thing that everybody knows. It's not. Most people don't know about coercive control in Massachusetts. I mean, one of the jobs that I have is with the Massachusetts Municipal Police Institute. I do domestic violence trainings with a partner, and right now this is what we're teaching. The new breakdown of how it works with coercive control. So it's a fairly new concept. And so, but he walked into a courtroom and said, I'm in a situation of coercive control, as if Kelsey was controlling him. So
let me ask you, I've got a couple of questions I want to ask, and then I'm going to hit a question from somebody out in the audience. But in terms of unification or reunification, what does that look like in Massachusetts? In Illinois, it's a pretty intense kind of program that they put whatever parent has kind of fallen out with the child. But how does that look in Massachusetts? And does the tender age of Caden have anything to do with how extensive that can be? Because to me, just on straight biology alone, I think it's going to take a very short period of time of the child being with his mother for that bond to recreate. It's not like you're talking about an 8-year-old that you haven't seen for 2 years. That's a different situation where you're talking about a young child, a baby still really, it seems different. So how does that work in Mass?
Yeah, well, I'm not sure how everybody does it, but I do know that there was basically a directive sent down by the chief justices, at least in my division, but it's probably, it might be system-wide, that, they wanted to, in custody cases, well, every one of my cases was a custody case, but, so mostly with the state, not all, but mostly with the state, but that we were to prioritize getting to trial or reunification for kids in the 0 to 3 age range for the very reason that you state, because there are issues there, where bonding, if a child is 8 years old, there might already be the bond and all of that. But when in the 0 to 3 range, and especially in the first, 18 months, you don't want to worry about things like attachment disorder and things like that, any kind of attachment issues, I guess I would say. And so, you really want to prioritize those kinds of situations. In the probate and family court, they're doing what you both have talked about, which is they want people to come to some agreement. And you heard that today. Oh, yeah, we've talked, there's some agreement. And then the other lawyer will say, well, no, that's not, that's not exactly how the conversation went down. But I think this judge, made clear that even though it's going to go back to the other judge, that, look, you better work this out, because I think it's clear and has been all along. Kelsey's rights are not going to be terminated. And this isn't going to end with her seeing that her child on Saturday and Sunday every other week. It's not going to end like that. She may well have full custody. It may be 1 week with him and 1 week with her, but it's very difficult in Massachusetts unless you work, in a conciliatory way. And I think one of the reasons that the lawyer today didn't like just start saying, when they were saying, well, we don't think it's safe, and the judge wasn't buying that, where she didn't say, well, why is it safe for the child to be with this drug user, who was taking LSD and smoking marijuana every day and drinking 2 bottles of whiskey. She didn't do that, possibly, because she didn't want to escalate. It's like, I'm not going to escalate the situation here. It's a temporary custody motion. This isn't the time to do it, despite, their attempts. But, you could see Justin standing there, and I don't know what you thought, but I think every time the judge disagreed with his lawyer and his lawyer tried to, just sort of back off and backpedal and say, oh, no, this is what Justin wants. You didn't see Justin shaking his head. Yes, that's what I want. You didn't see anything like that. So,
yeah. And let me ask you this. So with respect to, because I think that's huge. And again, our process here in Illinois, I think it's pretty progressive. I really do. So when we are able to work out what we call a joint parenting agreement here in Illinois, mandatory mediation is not optional. Like, that is always in there. And this is for folks that have been married typically, and now they're getting divorced, and we're able to work out the agreement ahead of time. And so in certain counties, it's absolutely required. You cannot walk into that courtroom and the first thing the judge is going to ask you is, did you do mandatory mediation? Because I want
parenting class.
Right. And did you try to figure it out? And that was the other thing I was going to ask you, because Ash and Sugar, thank you very much, said, will parenting classes be ordered by the court, like how not to bash the other parent or needle the child for information? Does that happen in Massachusetts?
Yeah, they have a 4-hour course. It's called two homes or 2 houses or something like that, that they have to do. It's on, it's online now. That stuff started after COVID. But before that, they had to actually attend them. But yeah, they are both going to have to do that. You hope that they get something out of it, but I don't, I just, based on the pleadings that we just saw coming in yesterday, I mean, I think that was the first time I thought Kelsey's lawyer really sort of hammered it home, because, Kelsey's in a good position right now. So,
and you know what? I was gonna summarize some of those real quick. The easiest one to start with was Kelsey's opposition to the motion for GAL. Mm-hmm. So Justin's asking for the appointment of a Category E guardian ad litem to investigate and make recommendations on mental health, physical custody, legal custody, parenting plan for the baby. And so my understanding of Kelsey's core position is that she didn't categorically object to a Category E GAL if one is appointed, but she was arguing that the GAL is unnecessary, will cause months of delay, and is being weaponized to keep her from her son, and that the court already has enough to set temporary parenting plan now.
Yeah, very, very wise move, I thought. I thought that was a very wise move by the lawyer, because when she put that in there, it's not just like, we don't need a GAL. It's like, as soon as you appoint a GAL, it's going to be 90 days or 120 days. And what she's saying is this mother has already been denied her parental rights. I mean, she's been separated from this. And if we have to wait 90 to 120 days, which are, usually is what gets assigned, there are times that I would say, I want to report in 30 days, at least a preliminary report to address some of these visitation issues, or just to address not necessarily visitation, but whatever else the issue was. So I would do that, but that's exactly what she did. She said, really, a GAL, as you pointed out, she basically said, look, what's the point, to us waiting? And I think the judge was very sympathetic to that argument, knowing that she hadn't seen her child. And so she says, I'm going to appoint a GAL. I mean, there was no question. I mean, I would have appointed a GAL. It's interesting, if he made the GAL relative to custody and parenting issues and mental health issues, but I didn't see anything in there. I don't know about substance abuse issues, since it was his motion. Do they want the GAL looking at those substance issues? Because I don't think he's back at his job either. But in any event, so I think she did a great job, opposing it, because it gave her the opportunity to say, look, Judge, this has been unfair all along to this person. And don't forget about the fact that this case is being watched very carefully by the higher ups, just like we talked about in the Superior Court, when all of a sudden the recusal motion was somehow moot by the Chief Justice of the court. And it's been like a musical chairs of judges in Essex County. You had two different judges in the Superior Court. Now you had, I think, Judge Black at one point, and then the judge who has the case now, and then the judge who heard the motion today. I don't know. It's just like every time I turn around, it's not how the probate court works. Right. When you file in the probate court in Massachusetts, a number gets assigned, and whatever judge is up next has the case. And they don't even look at the name or anything like that. It's like, this is your number. This is the judge who's up next. Yeah. And so I don't know. There's, seems to me, I could be wrong that this, well, of course we know in the Superior Court, but this case, I think that's why the case is going back to the original judge, because it's assigned by, it's attached to the file the moment it gets filed.
Yeah.
And that was something that I just want to make clear to everybody, that so when you're saying today was a motion judge, this is not now the new judge. That was a judge that courtroom hears motions, and that's like we have our child support room, and that's a cattle call. I mean, it's like everybody that's in there that's fighting over $15 a month is in that room, up to the people that are fighting over thousands of dollars a month in child support.
Every Wednesday in Worcester, Massachusetts.
Yeah. So it's a whole thing. It's a whole vibe, child support court. So I just wanted to be clear about that. So it sounds like it's going to get moved back to the original judge, which to me makes sense. Do you have any opinions on the original judge?
Yeah, I don't really know much about that judge. I mean, that's the judge that issued the restraining order, and I was actually able to listen to that hearing, and it was, to me, it's just unbelievable. The stuff he was saying. And at one point he was saying, and she kept hitting me in the face, and that it was very recent. And the judge was like, where was she hitting you? And he pointed to, she said something like, I don't see any marks, or I don't see any red marks. Well, my brother saw it. That's, the kind of thing that was going on in that hearing. Right. A manipulation, thinking that the judge is not going to notice. So I was pleased when I heard that. But again, I've been very vocal about the fact that judges are not supposed to terminate visitation without making findings. And while this was a unique case because she was in the hospital, there should have been, an opportunity for her to see that child even when she was being detained, and there wasn't. So, my big complaint about this case, as you know, all along, was a Superior Court judge stopping visits, and then it just sort of continued, because when they came to a stipulation, earlier, after, I don't know if it was right after she got out, and there was a stipulation, and they said something like they didn't raise the issue of visitation because it says right in the decision, visitation has been there is no visits per order of the Superior Court. So you had the judge in the Superior Court basically usurping the ability of the probate and family court to order visitation. So, I've said this a number of times, I think that Kelsey Fitzsimmons has been mistreated by the courts, with failure of people to comply with the laws and statutes that are out there that require judges to say exactly why they're separating a child from a parent. Right. So, but it is going to be the other judge.
And I think we'll see, like, once we get to her motion, and then when we cover the one that he just filed, why this judge kind of had no choice but to appoint a GAL. But key arguments in the GAL motion, as Judge Erskine said, first, Kelsey's saying, look, you have all of the facts and allegations. They're all right in front of you. You don't need the GAL to make a temporary decision, that there was no evidence that she's ever harmed the child. She pointed out that Justin had multiple opportunities to take the baby during these periods when he says mother was unsafe. But like even on June 29th, he went back to the house. He took personal belongings, but he left the baby with mother. And the day the 209 ex parte order, that Kelsey had asked him to come watch the baby while she did CPR training, and he refused. So she's like, look, he wasn't really worried. If he was really worried, he wouldn't have been just, making his moves. Again, she says it's a delay tactic. She also points out that father can't co-parent, which we'll get into more in the next motion, but that he wasn't even signing up for our family wizard account, and that he said it was a good communication tool, and that he was not informing her of certain medical updates and things like that. And she just said that all of her her mental health concerns are kind of under control. She issued reports, things like that. But let's get to the opposition. So, and this is what you were talking about, where you said she had a chance to really dig in and come at him in this. This is Kelsey's opposition to his motion for further temporary orders. They both filed their opposition. So starting with Kelsey's, she starts out with there's her argument that a willingness to co-parent, and she flips his own cited authority right back at him. She talks about the night of the 209A was vacated, that she opened in our family wizard account. And just so you know, that is a texting service where the court has access to it. And it's
Everybody does.
Right.
So the GAL, the court, and the attorneys.
Right. But it's already basically like, you don't have to go about proving foundation that this is a true and correct representation of the text. Everything's boom. It's laid out. It's there, and it can be admitted in court without any issues. And it's the way most states have parents and custody issues communicate.
I think it's a very effective tool because
sounds
you
like
got a lot of eyes on you. So it forces people to communicate, understanding that there's a lot of eyes on what you're saying back and forth to one another. So it kind of forces the parties into really watching their tone, watching their language, being careful of the things they say. It's forcing them to be civil, which I'm a kind of a big fan of, to be honest.
Yeah, I think it's excellent. It just makes so much sense. The question is, you can maybe, he can be civil, as his lawyer will advise him in that way. But you see what's in his, you can see, you
see it in his pleadings.
You can see where his mind is.
Yeah.
It's the same as when he was screaming to the police on the phone, if you don't do anything, I'm going to blame you. It's like tantruming behavior. And that's what I thought her opposition was well done, though.
Yeah. So she went on to point out that she opened up this account. She messaged Justin on April 14th and again on April 26th, sending him a link, offering to pay for his account. He failed to even open up an account. So he doesn't even want to communicate, but he failed to open his account, but had blocked mother by text. So Kelsey can't even text her, which the attorney said she had only learned about, I guess on April 21st, and that Justin himself argued in his motion that, quote, the parties must work together to ensure that all decisions are made after a meeting of the minds. He has made that impossible. Mother should not be excluded from the decisions because father refuses to communicate. And that's basically her willingness to co-parent argument. Would you say, Judge?
Yeah, I mean, I just think it's a very strong argument regarding whether or not he really is committed to co-parenting. I mean, how often did you hear his lawyer say that stuff today? And I'm like, wow, what a lot of bunk that is, because when you read this, as I had read it, I'm like, why are you doing everything you can from the moment he had that child? He's done everything he can to keep her out of that child's life. He was supposed to be providing her with updates. She never knew the child had surgery, right, for a hernia. He never told her about any of the medical appointments, nothing. He has done nothing but close her out of that child's life.
Yep.
And I will say this and continue to say it. Everything about him is about terminating her parental
Yep.
rights, keeping her out of that child's life.
Yep.
And I don't care what his smarmy lawyer says in court, what his disingenuous lawyer says in court. Oh, this is what Justin wants. And I mean, if I were listening to it as a judge, I would be like really indignant about that, because as a judge, I would be saying, well, excuse me, counsel, this is what you said in the motion. This is why didn't your client contact her? Why was she blocked? Why didn't he open an account? Those questions are all just so people listening to this, they're all going to be there. He's going to have to account for those things. And just showing up at a motion and trying to make yourself sound good by saying, and guess what, Judge? I gave her a visit because I'm so worried about the relationship and all of that. It's like,
Judge, I mean, it's textbook parental alienation. I mean, if they were to write a book, Parental Alienation for Dummies, like that would literally be the text of it in terms of everything that he's done. The one thing that I wanted to ask you, which is a very effective tool that they use here in Illinois, they call them, we have a pretrial, okay? And that's where we go back in chambers, just counsel, parties stay out. Parties are there, but we go back. Judge usually takes the robe off. It's a much more casual setting. And what I love about it is the judge really, in those types of pretrial hearings, back in chambers, off the record, really speaks their mind. And that's where you see the judge calling bullshit, like the things that you're talking about, where you'll never see it on the bench. You'll see that a judge challenge an attorney if they smell something's off, but they're going to do it, within the confines of the courtroom. So it's going to be much more tempered than it will be back in chambers. And that's not to say it's ever like both attorneys are always minding their P's and Q's when they're back in chamber with the judges, but it allows the judge to be less formal and to really kind of get down to brass tacks. And so much is accomplished in those pretrial hearings back in chambers, because that's where the judge really is laying it out to both of the lawyers. And the expectation from that judge is to say, okay, this is where I'm at. Okay. I need you to know, counsel for Justin, this is never going to be an every other weekend thing. This is not going to be a thing where supervised visitation is going to be long lasting. It's my goal to get mom with child again. I'm going to figure out, if I have to, if you guys can't figure it out, what level of visitation each parent is going to have, or what kind of parenting time each parent is have. And my goal is to be at the baseline 50-50, so like when the judge lays it out for the lawyers and cuts through all the BS and puts the pleadings to the side, that's when the lawyer, if the lawyer is a good lawyer, is going to go out and talk to their client. And the lawyer's going to say, look, this is where the judge is at. Like we gave it our shot with this thing. It's now time, now that we have an understanding where this judge would rule, if we went to hearing, this is where they're going to land. So again, it's really in everybody's best interest to come up with an agreement, because that's where we're making the rules as opposed to the judge making the rules, because you don't want the judge making the rules, because if it comes down against you, getting that changed is awful tough to do.
Yeah, I would say to lawyers, and a lot of times we had cases in the probate and family court, and then you'd have a 13-year-old kid he wouldn't want to visit. And then and it's so angry and so oppositional these parents are, that one parent would bring the kid into my court on a stubborn child petition and say, I want you to order this child to comply with the visits that are ordered by the probate and family court. We had that a lot. And, those things, again, just sort of require you to say to lawyers and to the parents, look, you have to be really careful about those. They don't call them in chambers conferences in Massachusetts. They don't call them chambers. They call them lobby conferences, like in the judge's lobby. And so, I mean, of course, that happened thousands of times, where you'd have lobby conferences on cases like that, where you'd pull everybody in, and, I would pull the lawyers in, because it would be the family court lawyers coming in, and I would say, look, knock it off. This kid's 13 years old. People are putting him in the middle. He's traumatized. He's, not doing well in school. And I lay it out for people.
Yes.
I'm laying it out. The key to those things, though, is not to say what, because lots of times you have to say, I don't know what I'm going to do. This is what I see so far. We need to do something so that this 13-year-old can go back to school, so she's not crying every day, that kind of thing, just sort of stepping in. I mean, in my court, lots of times I would bring the kid in and say, what's going on? Do you feel like you're in the middle? And I would just chat with these kids. But yeah, the lobby conferences or pretrial conferences, they're really important because you can lay it out as long as you don't step over the line. In Massachusetts, in criminal cases, you can't do that because there was a huge issue where, where a judge was actually arrested and charged with allowing an illegal migrant out the back door in some kind of conference that occurred at the sidebar. She denied it. I mean, but it was a big issue. And basically, they sent a message down from like the gods of the trial court saying there will never be a law, because she went off the record for 52 seconds at sidebar. And so they're like, you are not to have like lobby conferences or off the record discussions, at least in criminal cases. Yeah. But we were still doing it in cases like that, like you're talking about. The problem in this case is, I think what Justin heard today is, look, you're not getting the visitation plan that you want. It doesn't matter how many times your lawyer says, oh, we're in total agreement with you, Judge. Yes, Judge, oh my God, Judge, that's brilliant. You can say that all you want, but if you think she didn't read what you wrote, right, you're wrong.
Right.
But today is about, today was important in the sense that we now see where Justin stands, no matter what his lawyer said in court. Because you're just not going to get the judge, his lawyer's not going to say, you're wrong, Judge. You shouldn't do this. It's completely wrong. He did try to say, oh, we agree with this as long as the child is safe, always indicating that she's not safe around the child, despite the fact that he was with his buddies, at their little, whatever, their little group
party.
Yeah, the affidavit party. That he was there. And he had no problem leaving Kelsey there. So, and we can talk about that another time when we talk about, I don't know if you've seen the presentment letter on her suit, but that's a whole different thing.
No, I haven't seen it yet.
Yeah.
Well, so then she gets into the well-being of the child. That's at section B that Bob has up now. So Justin claims that he has been the primary caregiver for 9 months, is a situation of his own making. That's one of her arguments, that he locked her out using the 209A based on allegations she now characterizes as false and surreptitious, and that he kept her out during the period that her Fifth Amendment right against self-incrimination prevented her from defending herself in family court. She says the thriving without his mother framing is rejected as preposterous and as showing father's misunderstanding of early childhood and the role of a mother, and that the pediatrician's hearsay comment that the child is doing well, particularly due to him living with father and father's family in Stowe, it is challenged as out of context, no clinical notes, no question framing. And, basically.
And the pediatrician would probably deny that he said that, he or she said that.
It wasn't, I found it to be outrageous. Like, I would say, you know what? I see that you really don't have any interest in actually getting care for your child. You're going to a pediatrician where you can get him to say words that you think are going to, I'm not even going to get into it because that one really.
Again, here you go with the whole control and manipulation issue.
Right.
He goes to the pediatrician, so that he can get a leg up in his custody case. That's the plan. Like, oh, I'm going to get this pediatrician and then I'm going to write it. But she has her, which we can talk about in a few minutes. She has Dr. Zeisel, who actually had as a witness on a case, and listened to his testimony for a few hours one time. So he's an interesting sort and very, 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 very smart.
Okay, so then she talks about this early intervention specialist. I think it's Miss Romero, that she was concealed from Kelsey. The only mention in bi-monthly updates was like October 29th, 2025, where Justin reported that the early intervention specialist, or the EI, reported EI was recommended when in fact it had begun in July of 2025. The March 31st, 2026 update letter that he sent was not shared with Kelsey per the October order, and it appears to have been generated for litigation. So that's kind of them pushing back on that, and that Justin needed 2 additional professionals just to feed the child. Mother had no such trouble in the first 4 months, and this argues for
Against him.
yes,
That goes against him. I
Right.
mean, he's saying, I had to get help feeding the child because of what? Because of what? I
Right.
mean, basically what he's saying is,
I'm not a parent.
I can't
Either
breastfeed.
I can't feed my child and I don't know how to do it. Because it's interesting that he would say something like that, and without anybody saying to him, hey, Justin, this is not going to look good for you that you can't feed your baby.
Right. Right. I did not get it at all. And then there's this hernia surgery she does the rebuttal for. So he's claiming she didn't take the baby to his hernia surgery. So the rebuttal to that is July 2nd, 2025 surgery was rescheduled because the parties struggled to fast a hungry herniated infant, because you have to fast the baby before this surgery. That Kelsey asked Justin to ride with her to the hospital. He refused. And then after the 209A was served June 30th, Justin failed to take the child to the rescheduled appointment and let it slip 2 months while mother was hospitalized, fighting for her life, and could not communicate with providers.
Yeah, I mean, again, all of this is exactly the reason judges appoint GALs. This is exactly the reason, because you have a judge sitting there at a motion hearing who probably read this stuff last night. I mean, how do you prove it either way? I mean, she's making great arguments. And, you're going to have a GAL who's going to say, I mean, I've been a GAL hundreds of times in the probate and family court as a lawyer, hundreds of times. I mean, when I was a GAL, I call those people. I call the pediatrician. The pediatrician maybe the pediatrician knows Kelsey from the first few months. Then you're asking him, were there any problems with the baby when Kelsey brought the baby in? Were there any concerns? And it's like you said in the beginning, Bob, everyone's going to put everything in there that, seems to support their position. The problem that he has in supporting his position is that it's essentially a position of utter alienation. This is parental alienation that you rarely see, because it's involving a child who's like 18 months old. And someone who's doing everything he can possibly do to keep that child away from the mother, and then standing in front of a judge today who's not going to keep the child away from the mother, and then saying, "Oh, I want, that's what I want. I want that baby to be with the mother. I want reunification. I ultimately want 50-50."
She's like, I read 200 and some pages. I know what you were throwing down before.
Right. I know that you didn't change your mind in the last 15 minutes. I mean, that's what I would be thinking. I would be thinking, I know that your lawyer is like pandering here, telling me what I want to hear, but I can read, and that's the mistake you make when you file something like that. I mean, it's one thing to file and put all that stuff in. It's another thing to file and make it as appear that you just want to sever that relationship, all legal ties, all emotional and psychological ties, and then turn around and say, oh no, this is what I want. Because it's so clear that's not only, it's not what he wants, it's abundantly clear that he is, attempting to end the relationship so that he can live with his, I guess, mother and father and sister and all the people that are in the house, helping to parent that child. That's another issue. I don't know that anybody raised that, but I would be asking that as a judge. Because it doesn't say, I'm doing all this stuff alone, feeding the child. Really?
Yeah.
Is he?
Judge, I want to throw this question up because it kind of goes to the heart of the other side of this. And so Keminoek, I don't know if I'm butchering that, says 100% on board with the trial outcome, but why no equal scrutiny of both parents here versus assuming one side is truthful? Feels popularity driven, not objective. Can you analyze from both sides objectively? Do you have a response to that particular? I have a response, but I'd much rather hear yours.
Well, you mean, can I analyze both sides objectively?
I think generally is kind of the
Or is
question,
the
maybe
judge,
specifically.
or is the judge, well, I mean, that's what you have to do as a judge, and then you look at it. And so when I look at this, yeah, are there, and I've been very clear about this the last time we were there, that as a judge, my concerns would be, which is why I wrote about the Angelone case. My concern in Kelsey's case would be, are these mental health issues resolved? Because he makes these allegations about these things that happened at this party or that party. And the judge was concerned about, what was it? Was it something related to the wedding, something where they were both drinking? I can't remember what party that is. What the judge said, is, geez, I read that, and I have concerns about that. And, she doesn't really know what the outcome was. But again, the person that just asked the question, did the judge really look at it objectively? Because what did Kelsey's lawyer say? We didn't, we've denied all of that, all of those allegations. But, that's what you have to do. You have to look at it objectively. From my perspective, this stuff about Kelsey's past, when there were these, you have to remember how young they are, right? I mean, we were talking about stuff from 5 or 6 years ago. How old was Kelsey then? Was she
18, 19, right?
She's
Somewhere.
very young. So, so from my perspective, I'm looking at this and saying, okay, this happened and that happened. Well, obviously the academy, which is very hard to get into, the police academies, overlooked that stuff and didn't really find anything really concerning about it, again, because it happened a while ago. But from my standpoint as a judge, would I have appointed a GAL? Yes. Why? Because I want to hear from her therapists. I want to hear from the experts. I want to know, is there a nexus there or is there not a nexus there? Is there a connection? Is there a nexus between those mental health issues and maybe even some of the things that he's alleging and her ability to parent now? That's what it boils down to, nothing else. Just like with him, the judge is going to look objectively of, I would not be able to even say within hundreds or thousands of cases that I had where substance abuse was the main issue. So again, so now you have a judge based on her allegations in her filing about his substances. I would be gravely concerned about that. And I know people are disappointed because the judge kept him there. But I mean, I don't know what the judge is going to order, but I would be ordering that he have like drug testing, like, random drug testing. He's probably clean now because he can't get his job back.
He claims that in his next pleading that he did a hair follicle test and that they were clean. So,
well, I'm sure he waited long enough to do that.
Right.
Because you have to, if you're smoking weed, it's gonna be positive with it in 30 days. So I would, you would wait. You'd have to wait 30 days. Well, he lost his job. The only way he's getting it back is, one, if he's clean and has X number of clean and sober. But again, so why doesn't the judge, and I think any judge will, is the judge going to say, well, I don't see any nexus between the substance abuse because he's clean now. From my perspective, I want people to be clean for a period of time, though.
Yeah.
Because she's alleging very serious long-term drug use, long-term drug and alcohol use, long-term. I mean, she's saying, they're talking about many times that he was smoking weed every day, that it had acid in the refrigerator, that he took it out and that he was using it, that he was taking her anti-anxiety medications, because of course she had postpartum issues, and that he was using her meds. Well, I mean, as a judge, I'm going to look at that, because she got that medication. That's, again, fairly recent. That's not long. That's not long ago. I'm going to want to know that you have a parent who's not only sober, but I'm going to want, that kind of ongoing testing. I'm going to want a lot more information about that. And she's got a lot of evidence because she has the video of him where she's saying, where she's talking to him, and he's pretty inebriated. She has a strong case there. What I would say is, to the two of them, you can make these allegations against each other, and where is it all going to end up?
Right.
Because you can keep making these allegations. They're lucky that the Department of Children and Families, especially with his substance abuse, hasn't stepped in, and they can keep putting all this out there. And you don't know at some point if the state's going to say, you know what, we're not good with this.
Right.
And I didn't know until I read the pleadings that DCF was involved the day of the shooting. And so it sounds like the police did file a 51A. But as we talked about last time, what I talked about with Bob is he did the famous, what I used to call when I was on the bench, the rush to the court, the race to the court, we used to call it. Whoever gets there first and gets the restraining order and the temporary custody order is the person that's going to win for a short period of time. So he did the race to the court, because what that does is it undercuts DCF, because of course DCF's going to say, oh, well, the judge said he can have custody. So yeah, we're out of it, because they don't want to win it unless they have to.
Right. And then, so in C, she's saying mother's mental health and ability to parent. She fires back at the discovery issue, saying that she objected to certain things during the pendency of the criminal trial. But then on March 30th, she sent Justin a draft confidentiality agreement so she could supplement her discovery answers. He still has not returned an edited or signed version, and that she could have insisted on in-camera review. So, and cited some statutory authority for that. On
her mental health record.
Right.
Yeah. Right.
Yeah. Because
that's the only way I did it, was in camera review. And she's being pretty, magnanimous about this, saying, well, I might give him some. We talked about that last time with Bob when he put in there, I want access to her medical records. And it was very broad. The privilege issues in Massachusetts are very, very strict, very strict. There's actually a statute in these cases, in criminal cases and in cases in the juvenile court, in the probate and family court, about access to mental health information. And the rules are really strict about that. But, but generally, when I would review that stuff, it would always be in camera in order to protect the privacy of the person. And only after I reviewed it in camera and I thought it was relevant, and if certain parts of it were relevant, would I allow it in the testimony during a trial. But this overbroad claim he made that he wants access, this is what she's showing. She's showing an ability to want to work cooperatively. And she's not showing an ability to alienate him, saying he shouldn't be near the child because he has a drug problem and it's really serious. She made the case very strongly, but everything about his pleadings is alienate, control, keep control over her. And, because his back is against the wall, as they backpedaled a lot, I thought today, as his back is against the wall because he knows that the judge is going to order visits, because the judge kind of just came out and said that, like what you're asking for is ridiculous. He knows that, the judge didn't seem too clear about wanting to do it at a visitation center. I don't know what she's going to order, but I don't think it went well for him in that respect. So, the two of them, I think, what I will say about Kelsey is, it's very clear she seems willing to, to work out an agreement, and, she has sort of a conciliatory tone, and his tone is all about trashing her, putting her down, making up stories about safety, that may not exist. So, for the purpose.
Let me ask you, Judge, I'm sorry to interrupt, because this is an interesting part of it. And it kind of goes back to that question, because that aspect of, I always told my clients in terms of like a custody fight, I'm like, you want to appear to the judge to be the person who is facilitating the strong relationship with the other parent, because the judge is going to look very poorly at the person that is the one that's trying to alienate the other one, that's constantly throwing shade at the other person, saying they're not a good parent, blah, blah, all those things. Because if it boils down at the end of the day where the judge is going to say, okay, well, I'm going to give, here they call it primary residential custody to one of the parents, really for the purposes of school registration.
Right.
And I'm going to do that because, frankly, I think that this parent is the one that is facilitating the strong relationship with the other parent. And so they would punish the parent that was doing the things that Justin is doing. My question is do we think, like, if you're on the bench, are you trying to kind of wade through this? Justin, at least in his mind and his lawyer's mind, is in the position of power because he went and got that 209A. So he's trying to, like, if you're thinking of a poker game, he's the bully with all the chips. And he feels like he can just bully around. He can pull it. He push big stacks in on a shit hand. And then with, thinking that Kelsey's going to fold because she's got the small stack right now. On the other hand, you could probably make the argument, if you're the judge and you're trying to think through this, it appears that Kelsey is the parent that is more inclined to wanting to facilitate that strong relationship with dad. I want dad to be in my life. If I were Justin's attorney, I'd be making the argument, well, they're only saying that because they're in this position they're in now. They have to say that. She can't come in the same way that Justin can as a bully because she doesn't have the chips now. To me, like, that's one of the hardest things on being on the bench when you're hearing these types of cases. And it's so fascinating because this case is such an important case because it really is probably the highest profile custody case that I've seen, maybe ever. It's not in a movie, like where there's just a ton of eyes on it. It's kind of playing itself out in the public. And a lot of people are going to be able to relate to it because they've lived it themselves. You know what I mean? Whether it's from the father's perspective, whether it's from the mother's perspective. And, it's a tough case for a judge to kind of make their way through it ultimately. But what it really boils down to, I think you've said so eloquently, is you need to know what Kelsey's mental state and her mental health is like now, because that's what matters now. And if they can't show a nexus that there's some kind of problem based on her mental health, then as far as a judge is concerned, you're starting at ground zero. You know what I mean? Because that's no longer an issue. It was an issue at one point for whatever reason. If it was postpartum, that was it. If it was because her hormones were spiking up and down because she was pregnant, if it was because when she was young, she was drinking too much, whatever the case may be, what we're talking about is the now. You know what I mean?
Yeah. Excellent analysis. It's exactly, it is exactly as you say. This is going to be about what's happening now. And it was pretty clear from Justin's lawyer that he kind of understood that, because, he, despite his sort of pandering, they know he might be in that bully pulpit position, as you say, because he has custody of the child. But you see it, being eaten away little by little with the removal of the restraining order. And you see a judge today, saying, what's the problem with a full day on Mother's Day? I don't think there are safety issues. The judge said something like that. And you hear a judge talking about there's a connection. She needs time to bond with the child. Well, what are you going to do if you're Justin's lawyer? You're going to say, yes, Judge, I agree, despite the fact that everything I wrote, I don't agree. Yeah, I mean, I think, as we have said numerous times, if I were faced with this, my concern would be, I need a GAL to come in and tell me, it's okay that you're telling me that Dr. Zeisel, has said that, and what he's going to testify is right in there, right? I think, Allie, you have it.
We're about to get to it.
Yeah. So that's her strongest argument.
Right.
So she gets into the clinical record, and that's what we're talking about now. She started seeing this therapist, Emma Manderville, at Massachusetts General Hospital since 2024. The whole voluntarily admitted thing, she says she was voluntarily admitted to Lawrence General Hospital on March 9th, 2025, diagnosed with postpartum depression, and discharged after about 12 hours.
Right. Because
Right.
because they have to.
Unless they involuntarily committed her, which they didn't do.
They didn't, and they have to, they send you have to evaluate within 2 hours, which they never ever do. And then they evaluate you. And if you're discharged, then you're not a danger to yourself or others,
Right.
So, so that, to me, that essentially would be meaningless. Plus, it's postpartum depression. And so that's, she's been treated.
Transient. Right. So then she did the fitness for duty evaluation by Dr. Jill Durand, May 21st, 2025, ordered by was it Norfolk? No, North Andover Police Department. And that report was issued June 11th, 2025. So it's 2 weeks before the 209A. It cleared Kelsey to resume to duty, including use of her firearm without restrictions, no disciplinary issues, no complaints, no attendance issues. And now we get to Dr.
And that's no joke.
Right.
You know what I mean? When they're for the fitness for duty stuff is no joke.
No.
They are not trying to put somebody back out on the streets with their firearm.
Right.
If they're not good to go.
Yeah, exactly. And what it tells you is, that they believed that her postpartum depression had been resolved. This was a doctor who made the evaluation. And the reason, that that's important is because they argue in response to that is they cleared her for duty, and then she, was attempting suicide. And that's where Dr. Zeisel's opinion comes in. And, like I said, I've heard him testify. One of the last cases before I got off the bench, he testified for quite a while about, it was about a mental health issue. And the reason that, and if you just go back down in terms of what he says, Allie, if you can just move that so that I can just see above that paragraph.
Sure.
There. Yeah, where it says he reports that on June 30th, she was met with an unimaginable confluence of stressors experienced in acute transient psychological crisis. I mean, that's what's extremely important. As he later says, to a reasonable degree, as you know, psychological certainty. He knows the lingo quite well.
Right. And I think that really ties into the whole transient issue to the case that you cited originally. Yeah, that goes right back to Angelone.
Yeah, I agree, Allie. That's what they said, right, all along, that this was a transient thing, because what they need to get around here is she was cleared for duty, which means she didn't have postpartum depression. Then, and their argument will be, well, they made a mistake because obviously there was a suicide attempt. But then Dr. Zeisel steps in and then says, no, she was fine, but this was an unimaginable level of stress. And we all know what happened in that, that sort of brought on that very transient need or feeling to engage in a suicidal act. What brought it on was what you'll see, guarantee in the presentment letter, which I've seen, and exactly what happened that day, which is just how incredibly damaging this whole incident was to her, and the way they tried to, in the way the North Andover police carried it out, just the way they treated her, humiliated her, carried it out wrong, brought Justin there. All of those things, are the confluence of factors that Dr. Zeisel is talking about.
Right.
She's sitting there one day and all of a sudden her colleagues come in. It's humiliating. There's no social worker, there's no female cop. There's her supervisors.
She's losing her child. They're walking out of there with her child.
And then the dog was gone. And not only that, there's Justin downstairs with the sister, so it's an incredibly strong argument in her favor. And I will say, out of all the things I read that were filed yesterday, this is the strongest argument in her favor that's going to do away with the question of the mental health.
All those things that you just mentioned, the doctor says is that her acute transient psychological crisis clinically consistent with a severe state of acute emotional dysregulation brought on by all those things that you guys just both just said, and ultimately found that mother posed, quote, no credible risk of harm to herself, and that there was no clinical evidence she posed a physical or mental danger to her son. And you started to quote this: to a reasonable degree of psychological certainty, the risk of harm from reunification is all but non-existent.
Yeah,
So,
and he's a quite a witness. I don't know whether I agree with everything that came out in that hearing, but he's a very formidable witness. He's testified like tons of times. He knows how to use the language. Well, I will say to a reasonable degree of medical certainty, because we had him on the stand for quite a bit, and I had a lot of questions for him myself. But
you said it's Dr. Zizel? Is it
yeah.
Zizel? Zizel, okay.
I think I can't remember whether he said Zizel or Zizel.
Okay.
But anyway, I think her argument, I think that it's incredibly strong, and you can see, I mean, you're both lawyers, you know what's going to go down in trial. He's going to be the witness. They're going to call each of these witnesses. And so I don't know how much good it's going to do to bring this to a trial. I think a guardian ad litem is going to make a recommendation, and I do think it will end that way.
Right. And she just says that her current doctors are Dr. Z, she sees twice monthly, a Dr. Can that she's seen since January 2026 for medication management. She's got a trauma specialist, Dr. Nof, with intake done in a full session May 14th, 2026, that her current diagnosis is anxiety and depression regulated, no longer diagnosed with postpartum depression. And April 26th, she passed the 12-panel hair follicle test, and that's available to the court. And then there's this May 2025 letter that Justin keeps, talking about, and how Kelsey kicks back at that is she says she wrote it, she left it on the counter for Justin, was present when he read it, he hugged her and cried, and his representation that he just received it post-trial is a complete falsehood. So that's how she rebutted.
That's incredibly believable, right?
Right.
Because he has every reason to say he never saw it, but I mean, I thought it was, just very credible. And I mean, from my perspective, seeing what they both said, I would find that incredibly believable.
And context is everything, right? The timing of that letter is the context of that letter. You know what I mean? It changes everything. And, him being dishonest about when he received it is
Right.
shit, and I keep wanting to go back to that thing about like, why are people piling on Justin? And look, if you're to ask me objectively, it's best if a child can have both parents, assuming they're fit and well adjusted in that child's life. There's no movement from me on that. That is a perfect world. If you can have both parents, it's in the best interest of that child. If you've got two loving parents with them, the reason that the pile-on is happening with Justin is because of what Judge Erskine was talking about in terms of how he got her to that point where she is putting a gun to her temple and pulling the trigger. And it was everything that he did. Like, make no bones about it.
And it was calculated. We've seen it.
It was absolutely calculated. And it was with him and his mother hatching plans, affidavit parties, everything was going. It was a move to get control of that child. He never anticipated that it would go so far as, like, he didn't think that she was going to pull a gun and try to, shoot her, kill herself, and end up having, a bullet in her chest. Like I'm sure he didn't anticipate that. I think he just thought it was going to be this move. I'm going to run in. I'm going to get the 209A. I'm going to get the kid,
Right.
and we'll go from there. I'm going to be in the position of power. I'm going to have the custody. Good luck. It's a tougher fight. That's what my lawyer told me to do. You know what I mean? So, but that's why people are looking at it from the perspective of the way that he went about doing it. And there's no changing that. And any judge is going to see how he went about doing it. And if you think that the judge isn't going to take that into consideration, you're nuts. They just are.
Right.
Yeah,
So
it's so obvious, to me. It's so obvious and it's so clear. And you look at the Angelone case, and that was the kind of fight, 40 years ago. With him just and it's interesting because they use that word superior, like I'm the superior, parent here. And this is isn't that what Justin's saying?
yeah,
I'm the superior parent. I do all this and I go to the pediatrician and I do all of this. So the child should be with me because I'm the superior parent. And then you have the judge saying, look, the GAL, the psychologist, met with, in that case, the psychologist met with the mother's providers, just like you're going to see here with with the mother's providers. And then he turns around, and it's interesting. And then, as you pointed out, where it says Gino is obsessed with controlling the mother, with having complete control. So it's kind of an interesting parallel, isn't it?
yeah,
Mhm.
for sure, for sure.
Yep.
So then she goes through these incidents that he keeps bringing up. So the North Carolina assault, she says it was one plea to simple assault, 100 hours community service. It's been expunged when she was 21. Justin knew
21.
about it. 21. Justin knew about it, moved in, had a baby with her, proposed marriage, and now raises an expunged 8-year-old incident. 8
Okay,
years
and you know what we call that in Massachusetts, when that stuff comes up in a case like from 8 years ago on a simple assault. The word that, I would always write in my findings is this information is
Stale.
not relevant because it's stale,
Right.
and that's the lingo always used. I mean, that's just one way to talk about what you just read, and it's just stale.
Right. So she claims she never attempted suicide in high school. And then this Michelle Mitchell, I guess there was a deposition. And she says that Mitchell admitted she tackled Kelsey on the steps, bear hugged her, threw her into a wall, stood over her, and that everyone, including herself, had been drinking. That Kelsey kicked her in self-defense. Mitchell admitted she did not actually witness anyone pull hair. She did not know who pulled hair, and admitted after testifying that Kelsey's reaction was not normal, that she, quote, can't define what's normal and not normal because she didn't hear what was said. So that was Kelsey's combating that. Then she went through a month to month. You've got September 2024 through June 2025. That Justin's car speeding, Croatia trip in December, the Mexico wedding, the March 2025 breakdown, the May 2025 dinner, the child falling off the bed incident, and the June 2025 mercy meal addressed, in detail there, with the theme being that she continued to ride in cars with father, drive him when she was intoxicated, and live with him through every alleged incident, undermining his stated, fear narrative. She quotes his own text.
The absurdity of it is, right, with all these things, that he was sleeping with her, living with her, marrying her, all of all of these things that he's alleging. And again, again, this is all, you have a judge in a motion hearing. I mean, despite the fact that the judge read all of this, you can't possibly just make any conclusions about this. That's not what she's there for in the motion session.
Right.
She's there to say, this is a mother who hasn't had this kid. We need to resolve this. And let me be clear about this, and I've said this numerous times. If anyone thinks this case is not known to people in the trial court, the justices in the trial court, and the administration, as far up as it can possibly go. If anyone thinks that that's not happening, I got news for you. You're wrong. They intervened. They clearly intervened with the other judge in the Superior Court and took her out and put the other judge in. I don't care what they say. Like that was the Chief Justice coming down and saying, "Oh, this is moot." Another judge was. It's like I just it doesn't even have any bit of believability, and so they're well aware of it. like I said to Bob last time, I said, the trial court has a tendency to circle the wagons when this stuff is out there and people are saying you have someone who's not being treated fairly by the system. And then you have a judge today, who, who for whatever reason, however she was there, she was, I think, just making it clear she was trying to be fair. She was trying to say, reunification, connection to the child, bonding to the child, there needs to be visits, all of those things. But she's going to do what she needs to do to make temporary orders to make sure that Kelsey's seeing the child, and that everyone understands the goal is reunification. It's kind of like what you said before, Bob. It's kind of like pulling people aside, in the lobby and say, look, come on, people, work out something. You can't think that I'm going to say that a mother is not going to have visits or 1 hour a week. You can't possibly believe that. So what are you going to agree to?
Right.
So they get forced into, I'm sure you've both been in that situation like a million times.
Yeah. And those pre-trials always happen on the eve of trial. So that would be after maybe a year, 2 years of litigation. So the judge has heard and seen it all. So, the judges really form their opinion at that point. So when they go back there, they are basically saying, look, I've heard all of it. I've seen all the arguments. I've heard the evidence. We've had 15 hearings leading up to this. We're on the eve of trial. I am suggesting to you that this is the way that I would rule, most likely. They always leave a little.
Right. Unless I hear something different.
Right. But this is where I'm going to land on this thing. So figure it out. Get out of my courtroom. Go talk. Hammer something out. Let's get this thing done.
Babe, go back up to May. I'm sorry. I want to see what she said about. Sorry, I just cut you off.
No, you're good. Let's see.
The baby falling off. That
May, or were there two May? Oh yeah, that May.
With respect to their son rolling off the bed, she admits this occurred, but to convey this to the court as though mother cannot care for the child is disturbing. Mother had already woken up about 6:30 a.m. that morning to feed their son, and father was at work. Clearly, he knew she could care for their son and left mother and their son home together without pause. Mother and the child's routine at that point was to wake up early, feed him, and allow him to go back to sleep in the party's bed until approximately 10 a.m. So he did roll over the pillows at 3 months old. Yeah, that can happen, and fell off the bed onto a pillow.
Goose is on the loose.
Right.
I mean, Ayalain and I have had a lot of kids, and, we always had, we love to have the baby in the bed with us. You know what I mean? And it's like, if you happen to fall asleep, you worry about it, but you stick those pillows up as the walls, if you've got the baby in the bed with you. Right?
You do the best they can, of course, as it's not recommended, although then there's the other, there's the whole other belief system about that, children, do better when they sleep in the bed with parents. It's difficult that this would come into many cases that I had where the Department of Children and Families would say the child rolled off the bed. Not that was the issue that brought it in, but they would literally, say, when we would be transitioning the child home, that the parent couldn't sleep with the child. So it's very difficult. I had 2 cases where children were sleeping in the bed with parents and died from being smothered. And
those were those newborns?
Yes.
Yeah. It's not it's not a restful sleep. Like if you've got but Allison was always,
that was just how I was. You should not sleep with a newborn, but
no,
I I've had kids since I was longer than I've been alive. I've had kids, but I just didn't move,
you do it safely.
Right.
There's that's probably one of the biggest things in terms of infant care that's out there. There are 2 groups of thinking in that. There are 2 modes of thinking. There are the modes of thinking that you sleep with the child and the child, the child, as long as you can do it and the child will be safe. There are millions and millions of people that say that's much better than taking a child and putting the child in the crib. And then there are people, including physicians who say in the very newborn period, you have to be careful, for that reason. But
Right.
I
Yeah.
don't criticize anyone for the decision that they make, because there's, like I said, there's two schools of thinking about that.
Yeah. And a 3-month-old, you're not rolling over and suffocating like you
Right.
do a newborn. And now like they make these little things that like basically a little
Yep.
shelfie kind of thing, and the baby lays there, and just for
Yeah.
that reason, like for a newborn, so you can't accidentally roll over on top of them.
Yeah. Yeah.
So then
Pretty-
she goes through the June 29th, 2025 to June 30th, and she's quoting back his texts where he says, Caden should absolutely be okay there. There should be nothing wrong with him. Is there? And then one of his texts, I'll pick him up if you need or want me to happily. Otherwise, I'm not coming over today. He sent a text that says what he needs is safety and calmness. This is all he needs right now. I'm not coming over there today. Give me space and stop, please. So, I mean, where is all this concern? Like, I need to come over. I need to be there. You can't take care of the baby alone. You're going to hurt the baby. And then when Kelsey asked again that he take the baby, he wrote, no, I will get it at some point tomorrow. I need space. Let me be, please.
I mean, there's a whole book called A Child Called It. It's
Yeah.
a pretty infamous book.
I will get it tomorrow. I mean, a lot of the stuff that he wrote, really it made it sound like he didn't really have much of a bond with that baby.
Right.
It's like when you're calling a baby how much of a bond do you have with your little boy? But I think, what you see in those text messages undercuts his argument, any argument that she was unsafe with the child or that she was a risk to the child. I mean, it basically, piece by piece, text by text, completely dismantles his argument that that child is not safe with Kelsey. And it's pretty clear by all of those.
Right.
What
And
it
then
shows is a guy who probably wasn't ready to be a dad. Frankly, when I look at it like that, because he's concerned about he needs space. I need space, and what the baby needs, what it needs, is a calm environment. So I'm going to step off. You keep it there. I'm going to go hang with my buddies. And it's like, which I'm not judging them. Some people aren't ready to be parents, and it's kind of thrust upon them, and maybe they thought they were ready. And then when the reality of it starts to hit, they're like, oh man, wow, I wasn't really, this isn't exactly what I signed up for. I didn't know that I'd be woken up every 3 hours, or, it's like all the shit that comes along with having a baby, a newborn. That's a stark reality for some people. And, again, I'm not judging people. Parenting's not for everybody, but you should probably think about that before you have a kid.
Right.
Yeah. I mean, I think when you're young, like they are, it's, it can really kind of upend your life in a way that, of course, that you don't expect. And you can see, what at times his priority was certainly not the child. And then so the next question is, why working so hard to keep custody of that child? Is it because you want to raise the child, or is it because you don't want Kelsey to raise the child?
Or because your mom wants to raise the child, meaning his mom, grandma.
Right. Is that what it boils down to? It's down to, I don't want to, I'll raise the child. I'd rather raise the child than give in to
Somebody's
Kelsey.
paying his lawyer. And for a guy who couldn't afford gas, I'm not thinking it's him.
Yeah, no, exactly. I mean, there's no way he's paying this lawyer. He's not working. Right. I mean, he told her, I don't have any money. I don't even have any money in my wallet. I can't afford. So
can't get gas. Drive over there. Sorry.
No, because I don't know that people are creating a GoFundMe for him. Like they raised money for Kelsey.
Yeah.
So,
right.
Yeah.
So then she goes into the recorded call that we've all heard. And if you haven't heard it, it's on other lives. But the father and his sister called the police department to ask how to prevent Kelsey from taking the child. He admitted on the recorded line that she was telling me she's planning on taking the baby up to New Hampshire, contradicting his court papers where she was going to go to a land far away. And, framing the lieutenant told the father on the record, we don't have the right to deny it. It's her child. And that they couldn't take the baby away from her. And then his sister chiming in saying, we need to get the baby out of her hands, and asked whether filing a 209A would let the police take the baby. And they explained only if there's a custody order in it. So that's what we're talking about, how this was calculated. And we're going to get to his pleading. So for that person who was like, well, can we look at it from the other side? And we don't know if either side is being 100% honest or how truthful they are being about their allegations. But allegations are serious enough where a judge has to say, all right, wait, I can't just say all's good. I need it.
Right. I need a guardian ad litem. The thing is, though, when you look at that phone call, you can see it's very clear that how do I do this if I get a 209A and boom, all of a sudden they're all in a little meeting together at someone's house, and then he runs in and gets the 209A and uses the term coercive control. It has this sort of the imprimatur of strong planning, as I always have called it, the race to the court.
Yep.
And it unfolded in a way that, just is that no one could have predicted.
See, but in Massachusetts, you guys can get competing orders. In Illinois, no. It's verboten. You can't get competing orders. So it really is a race to the courthouse.
Yep.
So the first one to make it and they get the order, they win.
Yep.
And that's which I kind of hate and I kind of like. It's a double-edged sword, because it does. I think it creates a situation where where a person might be vacillating whether or not to do it. And because they're worried about having to be the first one because they're the only one that can do it, it may spur somebody on where if they maybe took a day, took a breath, had a conversation, maybe they're stepping back from it depending on what the situation is. So I don't know. It's all right.
And then before we get to his, I just want to say he's asking for this, like basically 42 total hours in a 2-month period. She counter proposed starting 3 weekly Sundays at 5 hours each Sunday with supervised visitation at her home, but with that paid supervisor providing a written report. Then 3 days a week, 5 hours each of those days, supervised by her parents. And then switching to a traditional, what they call traditional, is the 2-2-3 shared schedule where mom has every Monday, Tuesday, dad has every Wednesday, Thursday, and then they alternate the weekends. So
I think he's going to fight against that no matter what the lawyer said. Oh, we want reunification. I at one point I wrote down his exact word. He's like, this is I want this to succeed. That's what he said. That's what the lawyer said. And then he said, he, pointing to his client, wants this to succeed. But the way that he wanted that to succeed was, of course, by visits in a supervision center, because he said, it's the child that really matters. Oh, I just, because nothing in those pleadings is really about, the child. The child is really their primary interest. I just didn't see that.
Right. And for somebody, now that we're in his, and I'm going to start, babe, right at section 2, which is like the argument area, who's now saying, oh, I'm working towards reunification. He starts out by citing this Schechner v. Schechner case and saying where there's a pattern or serious incident of abuse, a judge must employ a rebuttable presumption that sole or shared custody with the abusive parent is not in the parent's best interest. So,
except she's not abusive.
Right, exactly.
So what? Why, I would be saying, why are you telling me this? Why, why are you telling me this? What I'll tell you, what of course, which we know is that, of course, in Massachusetts, the parents must be, absolutely, ultimately, and optimally cooperative with each other to share custody. And the only person who's not willing to cooperate here is him, which means she should be, in my view, the custodian, because he's not willing to enter into the kind of arrangement that would allow for shared legal and physical custody, or parenting time, as they call it here as well.
And that is what I wondered by his pleadings. Was he just walking himself right into a dead end by proving that he is unwilling, by keep insisting they can't co-parent, that he is unwilling to actually try, putting her in then the driver's seat. So I was going to pull up this Schechner case and read some of it to you guys. So I'm just going to summarize real quick, because we've gotten far. But here's like the type of thing that was happening in that case, where it was a pattern of serious abuse. So the judge documented numerous instances of the father's abusive and degrading conduct towards the mother before and during the marriage, including several instances in which the father threatened to kill or do great bodily harm to mother. In making a decision about the legal and physical custody, the judge said that they shall consider whether the child's present or past living conditions adversely affected his physical, mental, or moral, emotional health. They pointed out that in this case, the judge made findings that the father was domineering in his relationship with the mother and the child. The judge credited the GAL's observation that father repeatedly made negative comments and disparaging references to the mother in the child's presence, and spent considerable amount of time and impassioned energy impugning the mother's moral character. The judge also documented the father's lack of insight into the destructive nature of his behavior, his tendency to blame others for everything, his lack of impulse control, and the judge correctly noted a determination of whether a parent is able to separate his or her needs and interests from those of the minor child, and whether a parent's actions will compromise the minor child's relationship with the other parent are relevant factors to determine. They went on to point out that the order of protection was a result of an episode where the father was like denied an overnight visit with the child, and then like called and threatened to kill the woman a neighbor who got on the phone and said, "This is too much." The judge credited the mother's account there to the events that involved threatening behavior and impulsive misconduct directed towards her by the father in the presence of the child. So this is what we call a pattern of abuse. What we're seeing here, even at his worst allegations, are a transient mental health issue and possibly longer term alcohol abuse, if you accept what he's saying is true, was a huge problem in that period of time. Again, assuming what he's saying is true. But so that's the kind of case he's starting out the gate with, like saying,
which is interesting, because that case really it implicates him and the kind of things he's doing to the mother, because everything he says about the mother is exactly what that court is describing. The
Right.
pattern of abuse that's existing here is the pattern of abuse by him, of him denigrating the mother, making her sound like she's, severely mentally ill, which she isn't. The things that he has said about her being abusive and violent towards him, despite the fact that he was living with her, sleeping with her, having a child with her, leaving the child with her. Everything that he did belies the fact that there was any abuse, much less a pattern of abuse. But the pattern of abuse, as you read what the court is saying, is when you were reading this, I thought, is he alleging that, or is she?
Right.
As you were reading that, because the pattern of abuse is very clear in his pleadings. He makes it very clear, that how abusive he is towards her, how denigrating he is towards her, how he wanted to humiliate her by having the police go in. Everything he did to get that 209A, and it's mentioned even in that case, was really meant to take control of her, to alienate her from the child, to humiliate her, to punish her. So if anything, that case that case shows a pattern of abuse by him, and not.
I thought the same thing when I read it. I was like, this is sounding more like you than it does her. Now again, he highlights what he thinks are the are the worst allegations that he's made, but I just think any judge reads that as thinking this kind of speaks towards you. So he spends like a whole bunch of time talking
Right.
about how he had legal and physical custody for nearly 10 months since the child was 4 months old, and that the baby is healthy, thriving, well cared for, and meeting all of his developmental milestones. He says how
So
he
what?
attended, right, he attended all the OB/GYN appointments during pregnancy.
He's just mimicking what he said initially. I mean, this is
Right.
all the same stuff.
All right.
This is
Yeah,
like,
you're
right.
right.
Just basically his shtick. That's basically what he's been doing from the beginning. And he's the better parent. He's like the Gino of the Angelone case. It's like I'm the superior parent, and here it is. And this is why, because I have the child, because I've had the child. Again, I've repeated this many times, and I continue to repeat it. And I did this often in court. For example, when DCF would take a child away from the parent and keep the child away from the parent, they're the ones that created not only the bond, for example, maybe with a foster parent, by not allowing the actual parent, the bio parent, to see the child, but when it's your actions that create sort of the fracture between a parent and child, you're the person who's the abuser, in my view, because you created enough of a fracture by planning. And it seems in some of the pleadings here, the phone call, what if we get a 209A, we need to get custody. Well, that kind of planning is someone who it can be deemed as purposefully creating the kind of fracture that you need to separate a parent and child. And so when he's the person that created the breakdown between the parent-child relationship, you can't then go back and say, but I have the child now, and the child loves me, and the child wants to be with me, and I've done all these things, as if that means she's all of a sudden can't do any of these things. This is the other thing I want to say about this. This isn't like an 8-year-old child. I mean, this child's what, like 18 months? You think you can't create a relationship between the mother and an 18-month-old
14
child?
months. 14 months.
14 months. I mean, the
Yeah.
child's 14 months. I've had the child for 10 months. It's almost like there's like this, almost like this argument, the child likes me better than the mother. When you created the child, that's kind of like what he's saying. This child likes me better, so I should have custody. It's just an argument that just falls under its own weight. And that's, the problem. You can't be the person that stepped in and got the restraining order and raced to the court and then use it to say, now that the child's been with me, the child has to stay with me.
Right.
I mean, I've heard that argument like many times. I've heard that argument thousands of times, in cases, where a child's been removed by the state. Well, now the child's been out for too long. Well, you can't base it on that. A judge can't base it. There's no judge that's going to base it on the fact that he had the child for 10 months. That's
Right.
not how it works. I'm just
Right.
telling you, people, and people in the chat, that's not how it works.
Right.
And
And
as
then-
you both know, it doesn't work that way.
Right. So his paragraph 35 is him trying to create to outline this pattern of abuse. And that we
Very lengthy. It's
Yeah,
the same,
so-
it's all the same shit.
right. He's just
No,
he
it's not.
goes
He just repeats the same thing. There's no pattern of abuse because there's no abuse, at least
Right.
that I could see.
right. He talks
What-
about her driving 110 miles per hour while pregnant, hitting herself in the stomach, punching herself in the face.
She denies all that.
She denied that, yeah, and that she was destroying property,
What about
breaking
him being
things.
at home? What about him being at home, taking acid, being drunk, drinking the 2 bottles of whiskey, smoking weed every day? Where does that come into it?
Right.
So she did do a good job of arguing that.
Right.
This is why, so everybody who's listening, this is why again, as we have said all night, and as Bob and I had said, previously when we looked at the motion, when I said there's going to be a guardian ad litem, I mean, I mean, as a judge, if I had those 216 pages before me, I'd be saying, I want a guardian ad litem. I want someone to back me up here and tell me, tell me
what's what.
Yeah. Like, what's in here that makes no sense? And but I will tell you, there's just so much in there that I would ignore as a judge. I mean, stuff that happened when she was 21 years old, all that, not relevant in 2026. It's just not. So, he can repeat all that because he needs to put all that stuff in because he's trying to build something, but it's a house of cards, and it just, it just like I said, it just sort of falls under its own weight. It just doesn't add up.
Right. And then he denies her allegations. The alcohol, he says, no, I didn't do that. And I was never shaking at work. And
I never did fridge acid. Ever.
Right. He goes through this like horrible allegation in June of 2025 where he's claiming he finds her intoxicated and unconscious and naked on the living room floor, dressed her, and then he went to take care of the baby, and then he came back, she's naked again and non-responsive. And then he fights back at her allegation about also he took his 2 hair follicle tests that came back clean. But he says that she made this allegation that he was sending money, buying drugs from somebody. And then he notes that she supported this with a Venmo screenshot to this Robert Moore, one for $10, one for $15. So to me, that's not buying any kind of drugs. That he claims that he was
what Allison actually said. She's like, "What are we in 1990? Are they buying dime bags at the Mom Banks house over on 3rd Street?" I mean, I'm like, maybe people still buy dime bags. I don't know.
It did sound like that. I mean, the problem that he has in denying all this stuff about drugs and alcohol is that he's basically on administrative leave from his job.
Yeah.
Right. And we saw the videos of him all, smoking pot all the time. So whatever, though, it is what it is. So he denied it. He said that she claims he was doing Adderall, sniffing Adderall Christmas Eve of 2025. He's like, I was at work 24 hours, so I wasn't even at my parents' house. So, it's all that kind of thing. And then he's asking for what he's asking for.
Yeah.
Same thing.
Yeah. And as opposed to what he asked for in court today, it's like, oh, okay, Judge. Oh, okay. It's not going to be at the visitation center, and it's not going to be 1 hour a week. It's amazing. The backpedaling was striking to me, based on what's in there. And I guess maybe you feel like you have to do that because it's like, okay, I better agree to this, before I lose anything else. But when he's like, well, yes, it's like, oh, we want reunification. When he said that, Justin wants reunification. We want her to succeed. Does anybody see anything in what he wrote that shows that he wants her to succeed?
No, absolutely not.
All boils down to, I want her parental rights terminated. She's a bad person.
Right.
And she shouldn't have that child. That's really what this boils down
Here's
to.
what I want to ask you. My last question for you. Okay. So I agree. I think a GAL is mandatory in this particular thing. What does that look like? Because here in Illinois, it's typically they get 90 days, sometimes 120 days to conduct their investigation. What does the interim look like in this case, in your estimation? If you're on the bench, what are you doing in that 3-4 months period of time when the GAL's doing their report, doing their investigation? Like what are you incrementally doing? What are you trying to install in terms of upping the visitation? Like what would you be doing?
Yeah, I mean, I think I would be making orders saying over the next 3 months. I would probably in something like in this case agree with what the mother was proposing, that this sort of incremental thing happened. But I would put into that during the investigation, should the guardian ad litem see anything that would be contrary to that order, or if the visitation supervisor were to see anything contrary to increasing visitation. But I would want to see something incremental. I think what they asked for was very reasonable, and including having a professional supervisor and then moving it over to the mother, and what that screamed at me, and I don't know if you saw that, is all of a sudden he seems to have this not just animus toward the family, this hatred toward the family, which is really concerning.
Weird. Yeah, for sure.
Well, I mean, I think from his perspective, he's pretty much globally viewed as the bad guy. You know what I mean? So he's definitely feeling a certain way. And look, I mean, you made your bed, buddy.
Right.
I mean, you pulled.
If you had those concerns, you could have done it differently.
Yeah, look, in his defense, the dude didn't know the entire world was going to be looking at Kelsey's case when she ends up getting shot.
Oh, he thought he could be an asshole in private.
Right. He's just like, he thinks he's going to be the asshole on the QT, on the quiet tip, like every other dude that goes in and does this shit. Like, he had no idea that this kind of shitstorm was going to befall him. Yeah. So you know what? You got caught. You got caught being that guy, doing that stuff.
Don't you both think, though, because he knows that he's sort of, I think, publicly viewed as being controlling, and people heard those phone calls and just how he was screaming about what he wanted and how he was at the house, and that he's, and then people saw him in the house, taking things or whatever. Don't you think that, knowing that he would have gone in front of the judge, maybe a little bit more cooperative? I mean,
a little bit.
Maybe contrite's the right word, I think. Right. But maybe going in front of the judge in a manner where he was willing to be more cooperative with her and willing to work things out. But they didn't do that. And Allie, and Bob, and I know we've all had clients like that.
Yep.
We've all had clients that tell us, because, I was a lawyer for, a long time before I was a judge. We all have had clients who say, I want what I want, and I want you to take that position, and I want you to write all this stuff, because you have clients who think that they're so right about what they say. Yeah. It's the winning argument, without being able, and this is where lawyers come in to explain, look, all this stuff, like from 2018 and from, 2000, when she was 21, okay, you want me to put all that in, because you think it shows some kind of a pattern, but that's not how it works.
And those, Judge, are the clients that you're writing a letter because you're worried about when it doesn't go their way, even though you told them, look, this is going to have no effect. As a matter of fact, it's probably going to have a negative effect. I'm going to go ahead and draft you a letter that I advised you as such. So when you turn around and try to report me to the disciplinary committee saying I did a shit job, I want it to be noted that you've read this, that this is what my advice to you. Because like 100%, I'm telling him, look, man, you got to step off at this point. Like you really floored it. You had the pedal to the metal there, but now things have changed. And, like my thing with this dude is like, where is the empathy? Like, are you like devoid of empathy in terms of what the mother of your children or child went through? Like, are you incapable of like kind of putting everything aside and being like, damn, man, she really went through it. You know what? I mean, she damn near died. Yeah. She really, and like that lack of empathy is stark to me.
Someone he was engaged to, right?
Theoretically, he loved her. He was marrying her.
And was going to marry her. And you raised such a good point, because again, this lack of empathy and concern about what she went through and everything that happened. And where does it all float back? It all floats back to him. Yeah. So you wonder, is there a mental health diagnosis there? Is there a personality disorder? Or is he just, a guy that, just doesn't have empathy for her? I don't know.
I mean, usually when you're blazing up every day. It's just like, it's you're self-medicating, for whatever, because I don't know Justin from a hole in the ground. You know what I mean? It's like, I don't know anything about him personally. All I can do is look at what I've seen and, and what I've seen in terms of his pleadings. And, that's all I can judge on. You know what I'm saying? But I know that if somebody's using and smoking on a daily basis, they're trying to escape something. They've got issues that they're trying to self-medicate, and they're not going and getting whatever help that they may need. So, look, it's like every case that lives in the grays.
You don't really know what's there. You don't know if he's got his own issues, whether he's got a diagnosis or whether, he just believes intently that he's doing the right thing. I mean, some clients are just like that. It's like, no,
100%.
I mean, I'm sure you see it. So we've
All right, so I have not seen the hearing yet. We can let the judge go. I know she doesn't want to rewatch it, and you've given us all your comments, but I'm assuming that the people still want to watch it, right, babe?
I mean, you're super late on your 8:30 live there, little buddy.
I keep pushing it. So for anyone who has already watched the hearing and doesn't want to hang around,
you can barely hear the judge.
Oh, really?
I at least when I listen to you, can barely hear
it. What is it? Law girls, not attorney.
Yeah, just LGNA due process is the new moniker.
Okay.
Yeah.
So I think that they have they enhanced the sound, right?
Oh, they did?
I thought you said they sent you.
I've got it pulled up. Well, I know they cut out the dead time. I don't know if they got the sound better. Here, we'll pull it up. See what it is.
Yeah, out of curiosity, because I had earbuds in. It was very hard to hear.
And I'm going to put the boost on. So let's see what we got. All right. Okay. Okay. Stop screen share. All right. All right. And I'd be remiss if I didn't say thank you to Law Girls Not Attorneys for allowing us to use their content here. And we appreciate them. They're the hardest working gals in Massachusetts. They're running around in all these different courtrooms, that everybody's so interested in these cases and making sure that we're getting these videos, because sometimes, as today, there was no one else doing it. So thank you to them for doing that. Yeah,
it was great to be able to listen to it. I guess the only thing I'll add, before I sign off, is you'll hear the judge push back when Justin goes against having the grandmother supervise visits. They are very disparaging about the family. And then the judge, I wish I could have heard it better, but she said, well, didn't the grandmother do this? And didn't the grandmother do that? And he was like, oh, yes. So the judge was pushing back and wasn't buying his thing about the grandparents, trying to keep them. So I thought that was, and so you'll hear that, but you'll hear him say, it's the judge, it's the child that matters. I think the thing that probably bothered me the most is when he said, I want this to succeed. He wants this to succeed, which I thought was really interesting. And you'll see, I think what you'll see is a lot of backpedaling. But I think a lot of people, were upset that Kelsey's lawyer didn't push back enough. But like I said, I think she wants the judge to believe she's the person who cooperates.
Right.
And, that's not a bad strategy.
100%. Allison says it all the time. They go low, we go high. That's what we do.
Well,
it's a good strategy.
So, but anyway, so I'll sign off because, I've kind of said in the beginning what I kind of wanted to say about it. I was unimpressed with his lawyer. The lawyer interrupted the judge a lot. At one point, Kelsey's, lawyer was talking, and then he chimed in. He's sort of one of those lawyers that, always wants to be heard. He's loud. He wants to make his position known. I thought he kind of interrupted the judge at times. Yeah, I was not impressed with him, but as long as Justin's happy with him, I guess that's all that counts. But anyway.
Well, Judge, as always, we're incredibly grateful for you. I love having you on the show. It's such a fluid conversation. It's just, it's good content, and you're just so brilliant, and you're so knowledgeable, and it's helpful to people. It really is. Like, to be honest with you, this is like a CLE, a continuing legal education class for the audience out there. It really is. There's so much insight you're getting into how the sausage is made, because it's easy to kind of like watch this from afar and react emotionally, and it's incredibly important to kind of sit back, take a breath, understand how the process works. And there's just nobody better in the game than you, Judge, to explain how that goes down, So to me, I just adore having you. As I've told you, every time you're on, you have a standing invite here for anytime you've got anything that is of great interest to you, and you ping me, I'm putting you on. So thank you so much.
Well, I appreciate that. I enjoy really both of you, because you're both, it's pretty clear, that you're both excellent lawyers, the law, and that's what you do. You educate people, which is why I like doing this particular podcast, because it's a chance, at that time for three of us, I think, to kind of educate people and say, this is how the process works, and here's some things that you need to know, and here's how things work on the inside. I like to stay in my lane and be on about things that I know, and not be talking about, other cases when it's sort of not in my wheelhouse. But thank you both very much. It's always a pleasure.
Our
to
pleasure.
See
Thank you.
you.
Yes,
our pleasure. Thank you, everybody. Judge Carol Erskine, round of applause, please. Thank you. You're glorious. Thanks, Judge.
Bye.
Thanks.
Bye.
So I just want to say, law girls, not attorneys. They're recording this. They're providing it. So if you have not already subscribed, go follow, subscribe.
We'll wait. Just go over there right now. Go over there, give them a sub. That's how we do over here.
I'm hoping maybe we can do it at 1.25, but I just want to say, for anyone who's already watched this and is thinking of dipping, don't. We are, as soon as we end this, we are portaling you guys over to the Austin Drummond case in Tennessee. This case is outrageous. It has been suspicious from the jump. There is cover-ups. There are 4, quadruple homicide of an entire
snitches,
family.
CIs, there's all kinds of shit.
And now he is
that thing.
handwritten his own motion from jail, firing his lawyer and looking to represent himself. So that is coming up right after this. I switched it to after this, just hoping and praying that all of you would stick around, because that case is really something important to us. There are not enough eyes on this, and something stinks in Tennessee.
That's a crazy case where you heard about it. He was on the run. He was a fugitive from the law. 4 people got shot, and the baby, the beautiful little baby, somehow goes unscathed. And the person allegedly who did the shooting drops this baby off 40 miles away and leaves it in a safe place and calls somebody and says, hey, there's a baby you need to go get. It's a crazy, crazy case, and it really is worth your attention. Allie and I are, everybody accuses us of thinking everybody's innocent, which we don't, and which is absurd. But
this guy,
I don't know. I want to hear more.
Yes, exactly. Because I'm not feeling it. Exactly.
All right. Let's see what it sounds like.
Why don't we ask everyone? Does everyone want to rewatch this hearing right now? Have you all seen it?
If you've all seen it,
a lot of people are dropping off, so maybe no one.
Oh, they're dipping. They're dipping. The dippage. What are they saying? What are the people saying?
We basically discussed the hearing. So
yeah, we talked about everything.
Right. So
we talked about everything.
Whoever hasn't seen it, Proud Boomer wants to watch it.
We'll see what the sound is like.
Yeah, and try it at 1.25.
It is.
All other matters will be heard at 2 p.m. So if you're not here on the Fitzsimmons matter, all other matters will be heard at. Parties, please identify yourself and who you represent, starting with you.
Good morning, Your Honor. Kelsey Fitzsimmons.
Good morning.
Good afternoon, Your Honor. Julie Kelsey.
It is afternoon, isn't it? And I went right there with you. This is where we're at today. Good afternoon, counsel.
Good afternoon, Your Honor. Peter Tycho for Justin Ayalain.
Good afternoon, counsel.
Good afternoon, Your Honor. Justin Ayalain.
Good afternoon.
Good afternoon, Your Honor. Chrissy Candela, also for Justin Ayalain.
Okay, good afternoon. Can the parties please raise your right hands? You solemnly swear the great orders. I've read the opposition to the motion. I've read the motion to appoint a category E guardian ad litem as well, in the opposition to appoint a guardian ad litem. Did I miss anything?
Yes, sir. My brother has a motion also for temporary orders, and I did a verified opposition.
Yes, and I have that too. I have that too, and I have reviewed that as well. Where would Lee like to start?
Wait, I believe my sister filed first round, so I believe you should go first.
Okay, so do you want to start with the motion for temporary orders, counsel? So again, I know you've heard me say this. I have read it in its entirety. So if there's anything that is not in that motion that you would like to share with the court, I'm happy to hear it.
Thank you, Your Honor. And I do know there was a lot of submissions. I think there was almost 200 pages worth of submissions.
There were.
I appreciate that, Your Honor.
216, I believe. That's okay.
But I mean, genuinely.
It's important, and you both took the time and attention that is needed to have the court understand the history of this case and what your client's positions are. So it's my job to read it and read it thoroughly, and you did your job. So all is well.
Thank you, Your Honor. And with respect to the history, when I went back to look at all of the submissions to prepare for today, because there were so many, and there's
If
so
you be
much.
taking notes, I am paying attention.
And there is so much, Judge. And what I noticed, though, ironically, was that it didn't seem to be a clear actual history before the June 30th date when that restraining order was served. And I kind of want to take Your Honor back to that. I did hear what Your Honor said at the last case was before us. And yes, it is important to note there are a lot of allegations about domestic violence. But what is
Yeah, I think it's definitely, I can hear what they're saying. Plus we have, the captions, and I put a boost on. I think little law girl did a great job. That's what I think. I mean, it's certainly, I've heard worse. Let me tell you that. Like, I've struggled through some trials where it's like completely unintelligible. So, plus we have the captions. Can you all read? I'm assuming you guys can read.
What's important here in this particular case is that even father has not alleged that there's any abuse against the child or toward the child. There's never been any harm to the child. The child has never been endangered when with my client. If we back up.
So let me push back on that just a little bit, counsel, because there are allegations in your brother's submissions that there was physical confrontations between the parties and the child was present.
And you are correct, those are the allegations, and we are saying that those are refuted, Judge.
Okay,
Yes,
all right.
yes.
So please go ahead.
But what I wanted to focus on really this morning, we don't have a lot of time, Judge, is, the parties' history, right, before things blew up, if you will. They started dating in September 2023. Father moved into mother's home in North Andover in March of 2024. They conceived their child in spring of 24, and Caden was born in February of 2025. My client took maternity leave. She was on maternity leave for about 4 months, Your Honor. And in that 4-month period of time, they resided together. My client took care, was the primary caregiver of Caden. Father worked, he was a firefighter. And he also was present at doctor's appointments, things like that. The parties worked together. And I think that's an important history that this court needs to understand. We're not talking about two people who have never been able to work together and cooperate. It seems like that when we stand right here today and we look at what has transpired over the last 9 months, Judge. But that's not really the history between these two people and this child. They've agreed on the pediatricians. This is prior to June 30th, Judge. They agreed on where to go for the child for medical needs. They've agreed on how to raise the child. Clearly, they agreed on the home to raise the child in at that time, Your Honor. They were a family. Yes, things got disrupted, if you will, on June 30th. But father always trusted my client to take care of the child. He always left the child with my client. Then, yes, Judge, June 30th happened. That was the date that he obtained that ex parte restraining order.
But it sounds like there was, it sounds like from father's submissions that there was a lot leading up to that restraining order.
Yes, and I'm
Can you talk to a little bit about
yes, Judge. Mother was suffering from postpartum depression. She that started around February 2025. She got help for that in March of 2025. That's when she was diagnosed at Lawrence General Hospital. Father went with her for that. I did notice, speaking of the things that are not in our papers, Judge, I did notice from my brother's opposition that was just filed yesterday that they claim that Lawrence General Hospital had claimed that she should not be alone with the child. I did read those discharge papers, Judge. We're happy to provide that to this court, but it does not say that. It indicated that when she was going through that period, that one particular day when she had gone into Lawrence General Hospital in March of 2025, they said that was not a good circumstance for the child to be in. But when they released her about 12 hours later, they said that everything was okay. She needed to continue in her therapy. She was already seeing a therapist at that time. They had prescribed medication, and she continued in that therapy. My papers do lay out, Your Honor, that she saw a psychiatrist. She's still seeing a psychiatrist, a psychologist. She does have someone to medicate, to handle the medication. I believe it's Dr. Khan. And so she's continued in that therapy, Judge. So what we are submitting is that it was.
So let me ask you. So I'm in reading their submission, and certainly I'll give counsel an opportunity to represent his case, and I'll have the same questions, right? Even prior to that, though, there were some allegations of violence by mom towards dad.
Sure, Judge, I can address that.
You know, punching in the face and intoxication and violence towards a bridesmaid or someone in the bridal party at their engagement party, and even going back further when mom was pregnant with Caden. So can you speak to that, because the allegations are concerning and detailed?
They are. And I have addressed all those in my submission, so I just want to make sure everyone knows that. But I'm going to try to do it from memory right now.
Well,
so let's talk about the
opposition. I understand that there was some question as to whether or not things happened in the way that father's lens reported.
Exactly.
But there was, if you could give me some examples about that, because it didn't really go into this is what really happened there. Was there a punch? Was there not a punch? Right? Was there a slap on the back on the beach? Was there not? You sort of generally explained that things didn't happen the way they happened. So what happened? So that the court can make a proper determination of credibility and whether or not this child is going to be at risk if in mother's care, whether supervised or unsupervised.
right. So it's going to be hard for me to speak to each incident because there were a lot, as Your Honor can recall. So I'm just going to try to bring up some
Overall, right.
Right. So first of all, with respect to the allegations of punching herself in the stomach, that's a serious allegation.
Correct.
My client alleges that never happened. So to try to say something happened instead is difficult, right? Because it's basically saying I'm trying to prove something that didn't happen, prove the non-existence of something. We would suggest that we can look at the credibility of those statements. You know, several times father would say mother was driving from an event, driving father and mother, and I don't know if they were boyfriend at the time or fiance, but they were together, the parties were together, and she would speed at 110 miles an hour. He made the allegation twice. And what I want Your Honor to see is that he asked mother to drive him when she was pregnant from those events because he was the one that was intoxicated. He was the one that had been drinking. That's why she was driving. That's why she went with him and was driving, because he was the one that got intoxicated. So in a way, Your Honor, we're alleging that father's twisted those events literally in the opposite direction. And he's doing that because it's very easy to do when you look back at someone's mental health and you say they suffered from postpartum, they cried a lot, they were upset a lot. You know, even mother says, I recognize something was wrong in me. That's why she sought help, right, Judge? But to suggest that she punched herself in the stomach, he never called the police those incidents. He never went to the doctor. He never went to the pediatrician afterward and said, hey, can you check on these things? He never went to the OBGYN and said, hey, she's been punching herself in the stomach. There's no medical records to say any of that happened. And you would think, Judge, if that happened, those serious incidents happened, he would have spoken to the OBGYN because he even alleges he went to those appointments with her. And she doesn't deny that he did go to those appointments. So these allegations are coming years after the fact, a year and a half after the fact. Some of them he's talked about 8 years ago. He didn't even know her. But that being said, Judge, the allegations of punching and stuff never happened. She never assaulted him. Never. A lot of these events, she would be upset with him, Your Honor, and they're absolutely sometimes had an argument. Like, for example, that one time that he was talking to another woman at an event. She was upset, but he was drunk. He even apologized to her for how he behaved. When he went to Mexico, I believe it was, he had blocked her from his phone so she couldn't reach him, and she ended up being in the hospital when she was pregnant. I think there was bleeding, I'm not sure, but she went to the hospital. And so yes, there were incidents that they argued and were upset with one another, Judge. But to suggest that she was abusive to him or their baby, really, it's not credible when you look at the overall allegations, Judge.
I know that there was a visit, I believe, on April 25th.
Yes, on Saturday.
And that was with Dad, and that was at counsel's office.
Yes, Judge.
And that was arranged by Dad. Is there, prior to that or since then, has there been any time between mom and the child?
Absolutely not. She's not seen her son since June 30th, 2025, Your Honor.
Okay, let me hear from you, brother. Yes, please, counsel.
Thank you, Your Honor. Please, the court. Your Honor, I'm disappointed that I'm hearing that there's no acknowledgement of the past abuse because we just want to move forward. And we're taking a very positive approach to the case, Judge. What you don't see in the paperwork, maybe you do a little bit, is that I've worked with my sister proactively since we became involved in this case. Every single court order.
They're in agreement.
Is that agreement? So there hasn't been this, they're painting my client this picture that he wants to delay and obstruct hardly.
But why has there been no visit whatsoever until a week before the hearing?
Your Honor, we had been in front of the probate court and candidly, they didn't ask for it. And I actually suggested the visit last Saturday. I felt.
But whether they asked for it or not, we're talking about what's in Caden's best interest.
Agreed, Judge.
Looking at Caden's best interest, why was that not offered?
I think the issue was there was a criminal trial pending, Judge, and the focus was on that. The focus was on that.
Okay.
We had been in court, but I'm the one who moved that forward, Judge, and I was happy to do it. And I think Ms. Fitzsimmons will tell you, we were kind to her, we were supportive of her in that visit.
The visit went well?
It went well. I think it was a little awkward for everybody at first, but it did go well. My client's only concern is Caden's safety. He's 14 months old. He can't tell us what goes on in visits. When you look at, and I appreciate the court looking at the voluminous filings in the file, we've given the court very detailed, very specific accounts of violence that occurred, of behavior that occurred, self-harm behavior that occurred before the pregnancy, during the pregnancy, and after the pregnancy. Now, even if you just discount all those sites, there's things that mom has admitted to in her opposition. You know, the guidance thing is what I want about. The hospitalization, the things that led to that hospitalization. Her own family had, supported my client in right prior to that hospitalization, getting her help, looking for help. So to hear that, their position is she never assaulted him. Well, and that just flies in the face of evidence, even from third parties that you pointed out, Your Honor, in your comments. The bridal party. You have information that other people were assaulted. Mom was struggling. She was struggling. We understand that.
Does Dad still think she's struggling? Because what I'm hearing from Mom's counsel is that she's in therapy, she's on medication. I don't know if she's been cleared by her employer. I read something to that effect.
Not employed, Your Honor. Okay. She resigned in December of 2025.
Judge, we don't know.
But she was cleared before that.
We don't know. I do have a report from an expert from the criminal case from a year ago, which I can speak to. He's a paid expert witness. We don't know. And I think, moving forward.
Do you believe that mother is being dishonest about the fact that she's currently in therapy and on medication?
I'm not saying anyone's being dishonest, Your Honor, but I haven't seen it. I haven't analyzed it. That's why I have a motion for a jail. I think a jail would be perfect for this case to analyze that data and see that information. They can even have information, Judge, from a psychiatrist, psychologist. I'm not qualified to interpret. I'm not in a position to say, oh, sure, that's good enough. When we have a 14-month-old child and we have this long history, and my message to the court is, Judge, we want to move it forward safely, in a controlled way, candidly, Judge, so it succeeds. I want it to succeed. He wants it to succeed. These people have a long way to go with each other. They have 18 years plus. They have a lifetime to go. And these are very important days in their lives right now. Very important day. Can I be honest with you, Judge? Heck with him, heck with her.
I would hope that everyone's going to
I mean, to be candid, Judge, it's the child that really matters here. Okay, they both have their rights. The court will protect each of their rights, but it's a child that needs to be protected because of his young age. As you pointed out, I don't know if you remembered what happened way back when those arguments to domestic violence happening when he was an infant, but I rest on the papers I filed with you, Judge. The record is very clear, and not just confined to things that I brought up for my client. There's other things that, third parties, things that Mom has agreed to and admitted to. We both agree that the parent touch be supervised. We just don't agree on for how long, and what that looks like. We've talked.
So I have read that there was some agreement to have a professional supervisor. Is that correct?
Right, Your Honor. I'm not discounting concerns of this court or anyone. But we also aren't afraid of what anyone's going to see. My client is stable and looking forward to try to co-parent. We're also not trying to say dad's a bad dad. We're just saying Mom wants to be involved. So, but my problem, if I can just touch on this very, very briefly on the GAL, Judge, we also have no problem with GAL being involved. We have no problem with providing the records. I read that in my submissions. We'll provide all of our records, but there are some protections that we need to have too, Judge. So the problem and my concern with the GAL is that, as we all know, GALs take a few months, and that's understandable. I can't have a GAL taking a few months and no parenting time.
Correct.
What I also would worry about is, let's say the GAL suggests implementing.
Yes, a quick question. Is your client's position that there be no parenting time until the Guardian of Litem investigation is complete and the recommendations are provided to the court?
Not at all, Your Honor. In fact, I have offered, if you look at my prayer for relief, my motion, that entity I had contacted the clinicians. We could have started that weeks ago.
But your client's up.
Yes, Your Honor. What they offered was at a center. It's a very sterile place for a 14-month-old and mother to reunite. For less than 2 full days over 60 days, Judge. That's not a reunification. That's punishment. That's not co-parenting, Judge. So what we suggest, that's why I thought, let's start with a little bit of supervision.
At home with the supervisor.
At home with the supervisor. I provided a photo of the room that she has set up in New Report in her home with a supervisor, short period of time. Then we can expand that to just her parents or some. It doesn't matter who it is, but the child's also been cut off from her entire family, Judge, her entire family. So I suggest a stepped up parenting plan, and then maybe in the interim, we could have this GAL be doing all the investigation, reviewing records, but we need to start something more than 1 hour a week, Your Honor, or a few hours a week for 60 days. That seems absurd.
So there seems to be some agreement to a Guardian ad litem category.
Yes, sure.
You have someone in mind. If you want to submit recommendations, you're willing to do so. You're welcome to do so as well. As far as I believe that it makes sense, at least for the short term, for Kaden to remain primarily in dad's care because there is some distrust and some concern about past events. But that has to be weighed with the fact that Kaden has been completely disconnected with one person's body visit as well. And we're not dealing with purposeful neglect, we're dealing with mental health issues. So I think it's extremely important, yes, to keep Kaden safe, right, first and foremost. But equally important is reestablishing his connection with his mother. I think that has to happen imminently, and I don't think that 1 hour per week is appropriate. She needs to bond with this child, and this child needs to get to know his mother again.
I agree with you. And I'll point out, Judge, we weren't looking for it to be 1 hour a week. In fact, what I was suggesting was exactly the time my sister was suggesting her motion. It's identical. So it was not 1 hour a week. It was exactly what my sister had suggested her motion. So it compares really to the same thing.
I'm seeing some disagreement with your sister. Would you like to clarify, counsel?
Sure, Judge. I'm not sure what my brother's looking at, but we had suggested up to a few weeks for the initial supervision with a professional supervisor, and another few weeks with her parents as supervisors. And that took about 2.5 months for that, and then to bump it up to a 50-50 type parenting plan, assuming no issues or no concerns were again raised. So that's far more than.
Sorry, counsel. Does your client have concerns about the maternal grandparents?
We do, Judge. I don't think it's appropriate that they be the supervisors because they've been involved in this case too. If you read the reference to some of my pleadings as well, and candidly,
But I also read that they stepped up when help needed.
they did.
And he
Yeah.
called them.
We wouldn't, Judge. We wouldn't be
They
opposed.
behaved in a way that some may
Right.
argue were not in their daughter's
Understood.
interest.
This isn't a case where we're asking that they not be allowed to go to the supervised parenting time. We think it should be by a professional person. And the reason we had suggested a place, I suggested a place that the court does use frequently. Ken's 14 months old, Judge. I'll trigger this. An example on Saturday, he was on the floor. We had to set up the blankets. It doesn't.
How is that different from having a professional supervisor in the home? They're going to be
Well-
taking notes. They're going to be observing. It's going to be a licensed mental health care professional and a mandated.
Understood. I
reporter.
think the issue is who would that be? And
Well, they suggested someone.
right, it was absolutely inappropriate.
Why is she
Well,
inappropriate?
first of all, one person they suggested is out of Pittsfield, and her job is, I think she works on cases with Tim Brado co-counsel on criminal cases. I saw no experience in this area, number one. The second person was a woman with 6 years experience. I called her just to talk to her. I don't know if she didn't call me back. I don't even know if she supervises. I don't know if my sister spoke to her.
I think he's talking about her name's Ayalain Connell Canal. I think she was she was GAL on a recent case of mine, which wasn't perfect for my client, but I think that's what made her fair. She saw both sides, and I didn't realize that my brother contacted her. I had no problem with him contacting her. I did not contact her about this case either because I didn't want anyone to be biased when and if they were available. Just because she's had 6 years of experience doesn't mean she's not experienced with supervised parenting, and she is a qualified GAL and court judge.
But it doesn't say that she supervises. As you know, the court, we have a standing order.
Do you have any suggestions on?
No, you're right. I think
supervisor?
this is one of those cases, Your Honor, where we would defer to the court. On the JL, I am a JL as well. I would be like, and I have a lot of people I know who are JLs. This is the kind of case where I think if either party chose, it would be met with suspicion. I think it's the case where, as the JL supervisor, we would defer to the court.
So here's what would be helpful, though. I think I have two names that mom has given the court. It would be helpful if the DAC gives two names as well.
For a supervisor.
For a professional supervisor,
Okay, I'll
if
do
the
that.
court were to go that way, because I think it's only fair that each parent is able to suggest someone who they believe is appropriate. I will take this matter under advisement. I'm not your sitting judge, so this case will be heard from here forward by Judge Ulwick. However, I think the issue of whether or not a guardian ad litem should be appointed is imminent, and that is something that I will consider in my order, as well as a detailed parenting plan and what that would look like.
Your Honor, just one last thing. My brother and I both have in our papers that we want the parties to start communicating by OFW. I think that needs to start immediately. If Your Honor could put that into an order, that would be wonderful.
Yes, and I will refer to both of your proposed orders when I'm drafting the order for custodies, so I can make sure I can.
And my clients remind me, Mother's Day, if Your Honor could put in an order for that.
Absolutely. Mom should have Kaden on Mother's Day.
Your Honor, I have in my motion about popular wizard as well. I have a caveat in there that those messages between them not be disseminated on social media.
Absolutely
There's
not.
a lot of social media.
Absolutely not.
This is in this case.
We need to
photographs of
protect
child.
Kaden as
That
much
needs
as
to stop.
possible. Absolutely not. Mother's Day is, I should know this. I don't know this.
It's in 2 Sundays from now.
Sundays, okay. What, if anything, would your client feel comfortable with as far as parenting time on Mother's Day? What is your client looking for as far as parenting time on Mother's Day?
Anytime, Your Honor. Obviously, she wants as much time as she can have. She'd love to have him in the morning, all the way through the evening, maybe even be able to, feed him, play with him, those kinds of things. I'm sure her mother would also like to be present. But anytime, Your Honor, is wonderful for my client.
Your Honor, I just want to again stress to the court, our primary concern is the child's safety. The passage of time alone doesn't negate a lot of what's happening. We don't have any information about the stats amongst mental health.
You've plenty of information.
I don't think that one day reuniting with her mother and his grandmother and his maternal side of the family is going to put him at risk. I think that would be good for him.
I agree. I was there last Saturday.
Right.
So so I don't disagree, Judge. What is my client?
All right. I'll issue an order. Certainly, I'll get it out for Mother's Day so that we're clear about what parenting time is going to look like. Is there anything further that the court can do for ethical?
No, Your Honor.
Thank you very much for your time.
You're welcome.
Thank you.
And thank you for submitting such thoughtful submissions. It made the court's job easier.
Thank you.
Thank you for reading it.
I mean, well, first of all, thank you once
Your
again.
volume's back high.
Oh, really?
Yeah, I don't know what was going on.
It keeps turning off automatic for some. No, it's automatically. I don't know.
Oh, law
Weird.
girls, not attorneys. Great work. Thank you very much.
We're so thankful. Go give them a sub. Do it. They're
All
running
right.
around busting their butts,
Yeah.
literally on every hearing that people want to watch. You know how you can really kind of give them a thank you? Just go sub to their channel. It's free. They'll appreciate it. Trust me. Yeah. I mean, we had discussed all of it. So I don't
Yeah.
know. that we need
No,
to
read
really
the
talk
supers
about
real quick and then portal everybody over to the Austin Drummond and we'll have 10 minutes for
Carrie Cherry, I think I had pulled this one up. Will a judge ever ask questions, raise concerns about what's in the filings regarding Justin, drugs, drunk videos, job suspensions, or do they only focus on Kelsey? No. This is a two-way fight now. If it makes it all the way to a trial / hearing, it all comes in.
or it's all equally irrelevant because it was so damn long ago.
Right.
But yes,
some
they're-
of Justin's shit's not that long ago, though.
Right. They're going to look at both people.
Yeah. Thank you so much, Carrie. We appreciate that. Kendra, BZK. Oh, family hug. Welcome. Thank you.
Welcome.
Donnie Not Wahlberg gifted 5 DD podcast memberships. Oh, thank you so
Thank
much.
you.
Appreciate that. Family hugs to everybody who got one. Robin G gifted another 5 DD podcast memberships. Thank you so much for helping the fam grow. We appreciate that.
Yes, we
So
do.
much hope. 7144. Terrific trio. Hearts from Michigan. Thank you so much, Hope. We appreciate you always.
Stop leaving people. I'm watching you. You're
But
going to want to catch our Austin Drummond live.
yeah, where y'all going?
Don't go nowheres.
What you doing? What y'all doing? Bay Harbor, Beauty Unfiltered. Family hug. Welcome. So happy you're here with us. Appreciate that. Ash and Sugar. Will
Yes,
parenting
yes.
classes be ordered? I think we covered that. Thank you so much for your dono. We appreciate that.
Yes.
Tony, I am 76. We adopted our eldest from Guatemala when she was 6 months old. I went alone, and then the hubs came 3 days later, so I went for a walk. I came back. She turned her head, saw me, and smiled so big.
Aw.
Bonded. There you go. Thank you so much, Tony. We appreciate that.
Yeah.
HB Sunrider, like it. New member. Family hugs. Welcome. LGNA Network, law girls, not attorneys. Thank you so much. I think I asked that one as part of a broader question. So I think we got to that because it's true. I think it's important, sunshine disinfects.
I mean, and the judge definitely thinks that the media coverage is keeping everyone on their toes and eyes on it in the court system. So good
Yep.
work, law girls, not attorneys.
Yep. And then Kim, we got to this one. Thank you for the dono. I hope you were satisfied with the answer. I think it was a satisfactory answer. And Dr. Vonda K, thank you so much. This case is so important. We love you, Dr. Vonda. Thank you so much. Our daily angel, Kim, threw us another 25 on Venmo, which is our very favorite because
Thank
the
you,
tubes
Kim.
doesn't take their cut. So thank you so much, Kim. We adore you. All right, y'all. That's it, mods. We love you. You're in for double duty. We're going to head over to Austin. Drummond's case. It's really a crazy case. You should really check it out.
You got 7 minutes to go to the bathroom, get a drink.
Get some popcorn, and you're going to watch Allie talk while I go do other things. All righty. We love you guys so very much. If you're not going to make it to the stream, just remember, without you guys, I'm just an old man.
Sitting around talking to his wife.